Artist has not been filed, your lordship. Lordship may allow us by Monday or Tuesday.
Sir,
we'll file
injunction
urgent
method. If you want to kindly parents earlier orders, out of 4 days, 3 days, they took adjournment in last 3 days. Except the argument
Okay,
taken place on 18.
one day we can grant on Monday. On Monday, let them file the retentions. Heard Miss
S. Sharma on behalf of
S.
this matter.
Sharma, Learned Counsel for the respondent who prays for some time to file written gist of argument as directed by this court in its earlier data order. She submits that the respondent is unable to file the written gist as the engaged counsel for the respondent is out of station. Though learned counsel for Mr. R. Ali, learned counsel for the petitioner has objected to the prayer for adjournment. However, since a very short adjournment has been prayed for, same is allowed. Let this matter be listed again on Monday.
My return list may be accepted.
On 15th, the written gist submitted by learned counsel for the petitioner may be tagged with the case record.
Already furnished service.
Highly obliged.
May I please, Your Lordship, beg to mention item number 17. In this case, I have to file an amended memo of appeal, my lord. So Your Lordship,
Item number
17, I have taken the consent of the other side also.
amended memo of
Appeal, because substantial question of law has to be newly framed. So Your Lordship may kindly pass over the case today and let the matter may come in the next week. In the meantime, I will file the amended memo. of appeal.
heard Miss S. Roy. Your name is not there.
It is transferred, but in the miss case, my name was shown, but in the memo of appeal, delay was condoned then.
Heard Miss S. Roy, learned counsel for the appellant who seeks an adjournment on the ground, that the appellant has to submit an amended memo of appeal. As in the earlier memo of appeal, substantial question of law were not mentioned. She has submitted that she has informed the learned counsel for the respondent regarding her prayer for adjournment, who has no objection to the same. Hence, the prayer is allowed.
Next, any date.
Let this matter be listed. Did you? On 17th.
May I please, Your Lordship? I beg to mention item number 26, Your Lordship. Your Lordship, in this case, my senior R.C. Sancheti is here. 26. The other side is there.
This I cannot take it.
Yes, sir.
Heard Mr. S. Sancheti as well as Mr. B.K. Jain for the respondent. Mr. S. Sancheti for the petitioner and Mr. B.K. Jain for the respondent. List this matter before any other bench without me, within bracket my name.
Lord sir, here matter is regarding disconnection of electricity, your lord.
Next week,
So, no, your lord, next week I will not be. Tomorrow or day after tomorrow, your lord.
on day after tomorrow, Kitan. Monday. Tomorrow is Sunday.
Then Monday.
On Monday, on 15th.
May it please your lordship. Lordship, I beg to mention for listing of I for withdrawal of money deposited by insurance company. Next
When?
week, lordship, Tuesday.
Okay, Tuesday.
May it please, Lordship, with the consent of the other side, my lord, I am mentioning an item number 34, my lord, for upgradation, my lord. We taken at 2 p.m., my lord, if it is convenient. The last item, my lord, of the daily list.
No, why upgradation?
My lord,
Why to deprive others who are in before the
my lord,
you
this
in
is
the cost?
just an IA for withdrawal, my lord, otherwise,
It is IA for withdrawal only.
my lord, it's only for the IA for the withdrawal of the amount which is deposited, my lord. And here, my lord, the applicant is my lord, actually a cancer patient who is
Oh,
detected
okay, oh, okay, two.
at his deep replacement.
May I please your lordship, listed for a hearing all pending matter. On 16 or first week of January, all pending matter.
Hmm. 16th is not possible. Next week is Ocean Week.
Must. All pending matter. We are going to be victims. No, the degree cannot be executed for pending this matter.
You file a IA for expeditious hearing.
The matter at this stage of the hearing,
But there are many other old pending matters. Why to give preference to your case? You have to make out a case for that also. You file an IA. Or in the month of January on a date to be fixed by registry. Yes.
Lordship, I beg to mention item number 32. This matter pertains to the rectification 32.
32 is blank. There, huh? 32 is, there is no item in 32. Do you have any matter in item number 32 in your cause list? Huh? Okay. This matter has been wrongly listed today. So we will not take up this matter.
But for it to be listed before the appropriate bench.
It will be listed, otherwise also listed. Because in my cause list, it is not there.
Hearing be item 13.
Please, your lordship, the matter may be called after a short while. My senior is on legs in another court.
Okay.
14.
14 looks to be service report in respect of respondent number 2 has been received. Lordship.
Oximeter. We'll appoint one amicus.
Lordship.
A small pair be listed before the application.
Okay. Heard Ms. T. Som, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that the notice issued to respondent number 2 has been duly served. As no one has appeared for respondent number 2, this court is inclined to appoint one amicus. Suggest for
MK Brown.
amicus curiae to defend the cause of respondent number 2 in this case. Accordingly, Ms. M.K. Brown, learned counsel whose name appears in the list of amicus curiae prepared by the registry, is hereby appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish a copy of bail application along with annexures to the newly appointed amicus curiae. The registry is directed to reflect the name of Ms. M.K. Brown in the cause list as amicus curiae in this case. List this matter 18th of December.
Have the copy during the course of the day.
Today itself is.
It's up to date.
Item 2.
May it please your lordship. My lord, this is a transfer petition by the wife, my lord. Their marriage was solemnized on the month of May this year only.
Who filed the divorce?
Not the divorce, my lord, for nullity by the husband. That is at page 27. My lord,
Nullity on what ground?
my lord,
What ground?
nullity on the ground that she had affair with someone else or something like that. But on the other way around, he was divorced with another woman that we do not know. We didn't know. So that is my lord on merit. But
Okay.
this transfer.
Where, from where to where you are?
Yes, my lord. My lord, they have their household, that shared household was at Guwahati, my lord. They stayed at Guwahati in the Gitanagar area. The husband is working in Guwahati right now. And the wife is a housewife, my lord, without any job. He has filed a case in Jorhat
Why
But-
Jorhat?
because it is his it is his paternal house.
Where
Original
the
house.
marriage was performed?
Marriage was performed in both. It was Jorhat also in Guwahati also. But the shared household was in Guwahati. They stayed to live together for 4 months at Guwahati. And the husband was a erstwhile IRS officer, Indian Revenue Service officer. He is now posted in some multinational company in a very good position.
Where?
My lord. I'm just
Heard Mr. T.H. Hajorika, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner Urvashi Barua, praying for transferring of the title suit within bracket M number 165/2025 pending before the Court of Learned Additional District Judge Jorhat to the Court of Principal Judge Family Court number 1 Kamrup Metro at Guwahati. Learned counsel for the petitioner submits that the aforesaid suit was filed by the respondent, who is the husband of the present petitioner, for seeking a decree of nullity of the marriage between the parties. Learned counsel for the petitioner submits that the petitioner earlier stayed with the respondent in Guwahati after their marriage on when the marriage was conducted
on 5, my lord, on 10/5/2025.
on 10/5/2025. However, the respondent, by making certain false and fabricated allegation against the present petitioner, filed his suit under section 12 within bracket 1 within bracket small b, comma 1 and within bracket small c of the Hindu Marriage Act. Seeking a declaration, seeking a decree of nullity of marriage. The learned counsel for this petitioner submits that the petitioner, what do you do now?
I'm a housewife without any job, without any
Petitioner
income.
is a housewife without and is unemployed, and it may not be possible on her part to defend the aforesaid title suit by going to Jorhat on each and every day. At what stage it is pending?
Summons have been issued, my lord, and it has been filed for written statement, fixed for.
Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Stop. Considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, till next returnable date, the further proceeding of title suit within bracket M number 165/2025 shall remain stayed. List accordingly.
My lord. Deeply obliged, my lord.
Finding item 30.
PP also. Yes, Mr. Vishwas.
Case is not yet charged sheeted to my information, madam. Today I have completed 78 days.
What is the
May
offense?
wait for some more days, madam.
Here also, Lordship, I have a small play, Lordship. Here the two
It-
persons are accused of committing sexual assault on the victim girl. who is-
POXO matter.
POXO matter,
Yes.
who happens to a minor. Now, the thing is, Lordship, the FSL report is still awaited with regard to the blood sample which was collected from the present petitioner. And today morning also I have talked, Lordship, that report is within reach, Lordship.
Let it come first week of January. I have got no.
If they have no objection, Lordship, it would be.
And otherwise notice
Yes, your lordship has appointed amicus curiae,
Amicus was appointed on the
D.
last
Gogoi.
also absent. Wonder,
So if they are,
we have served a copy also.
they are agreeable, Lordship, so let it be.
Okay. Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional
Not really
public
common.
prosecutor. Though the name of Mr. D. Gogoi is reflected in the
78.
cause list as amicus curiae for respondent number 2, he is not present. Stop. Learned counsel, learned additional public prosecutor submits that though the case diary is available before this court, however, the forensic laboratory report with regard to the blood samples found on the
Newborn baby, victim girl, and the present petitioner has been sent.
blood sample.
DNA analysis.
For DNA,
For
whether I am responsible or not.
blood. However, forensic report as regards DNA analysis regarding paternity of the newborn baby is not yet received, and therefore he prays for some time for production of the same. The prayer is allowed. Let this matter be listed.
If possible, on 4th of this January, possible,
Both will be holiday. 5th will be.
4th is possible, it is Sunday.
holiday.
Sunday.
Oh, I'm sorry. Let me do on 5th.
5th. Let this matter be listed on 5th of January.
I may be allowed to upload the CD.
The case diary may be sent back to be recalled again after updation.
I'm obliged. Maybe the Lordship. If this is
Yes,
more of a mercy petition, what had application is, Lordship, 14 dates were taken by the plaintiff counsel.
14.
14 dates for filing her evidence on affidavit, examination in chief. Now, Lordship, after that, the impugned order, your Lordship will find at page 21. The impugned order was passed, wherein page 21, Lordship.
Who are you? Plaintiff?
I am for the plaintiff, Lordship. It was on 9/5/2024, wherein it was observed that as many as 14 dates were taken and examination in chief was not filed. And the ground that the petitioner was medically suffering, no documents were furnished. Accordingly, Lordship, the prayer for fixing of another date for evidence by the plaintiff was closed. And the court went ahead for fixing the next date for defendant's evidence. Aggrieved by this, Lordship, we filed an application for review. That also came to be rejected on 5/7/2025. That your Lordship will find at page 29. It starts from page 29. That was primarily on the ground that, Lordship, no medical documents have been annexed. Now here, Lordship, it's between two schools. The second school is a branch school of the first one. Essentially, between the mother and the respondent, number one is the daughter of the plaintiff. Now let's put the plaintiff
What is this suit for?
worship.
Suit is for what
Worship for-
relief?
For right, title and declaration over the suit property, lordship, covered by the respondent school. These are between two schools, lordship.
Between two schools.
Lordship. The second respondent school is a branch school of the, as per our contention, is a branch school of the plaintiff school. And the respondent school is now being,
At what stage suit is pending now?
now lordship, it was fixed for evidence of the defendant. Thereafter, we filed a review that was dismissed. Now lordship, it is pending at the same state as it was on 9/5/24.
Why it has not progressed? Why it has,
Lordship, since
is-
the review was filed, the learned trial court below did not progress in the pendency of that one. And aggrieved by that, we have come up before this.
no, is there any stay?
Lordship, now it has been dismissed
Review has been dismissed.
on 5/7/25.
5/7.
2020.
That order you are impugning in this case.
Lordship, that is annexure A3, page 29.
Now, after 5/7/25,
It has not progressed.
for last 5 months, nothing has happened.
Nothing else. That is my instruction. Your Lordship will kindly see the petitioner, a plaintiff, is a 75 years old lady and suffering from various ailments. I have annexed all the documents.
No, we have to issue notice.
I understand that, but till then, because it's fixed for defense evidence. Now, if that progresses, even if you're
No,
not,
but you don't have a case for any interim relief. For 24 on 20 occasions, you,
Lordship, 14 of it.
14 occasions.
Lordship, the ground we have taken is that they have stated that the council was engaged, have never informed us about it.
You are the plaintiff.
I am for the plaintiff.
Okay.
So for
So it is your suit.
I might. Now, Lordship, if but by this order, my evidence has been closed. That is, so, Lordship, I'm practically non-suited for the entire suit. So it has
Heard Mr. P. Sharma,
A Chakraborty.
A. Chakraborty, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 5/7/2025 passed by the Court of Learned Civil Judge, Senior Division Number 1, Kachar, in Miss J, case number 151/2024, arising out of title suit number 129/2022, whereby the trial court declined to review its order dated 9/5/2024, whereby it had closed the evidence of the plaintiff and fixed the suit for adducing defense evidence. The contention of the learned counsel for the petitioner is that the plaintiff, which is a school, is represented by, who are you?
The principal cum secretary of the school.
Principal cum secretary of the school, who is a ailing lady, aged lady and suffering from various ailments. And the trial court did not take into consideration the fact that the petitioner was unable to adduce evidence on the date fixed by the trial court only because of her ailment. Stop.
The ground is that we were not informed by our counsel that these dates were fixed. That is our specific ground continuously, even in the review.
Not what you were not informed.
Lordship, the council did not inform to us that these dates were fixed for examination in chief.
He also submits that the engaged counsel before the trial court did not inform the petitioner regarding the stage at which suit was pending. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Stop. Further, considering the submissions made by learned counsel for the petitioner till next returnable date, further proceeding of title suit number 129/2022 is hereby stayed.
Much obliged, Lordship.
List accordingly.
Item 4.
Lordship, here in this case, due to non-performance of the contract between the respondent and petitioner, Your Lordship, the one case has been pending before the Dibrugarh in title suit case number 33/2021. Nothing has been progressed, Your Lordship. So as per the page 33, the list of witnesses also been there in title suit case number 33/2021. But thereafter, since 2021 to 2025, Your Lordship, pending has been there, long pending. My humble prayer before is about to let give Lordship may give a direction to expedite the matter.
Where is the last order? At what stage it is pending? At what stage suit is pending now?
Lordship, last case, it is in my, before filing of this case, Your Lordship, it is on certified copy.
At what stage it is pending?
Hearing,
Wow.
evidence of it.
What is the last order?
Last order, Your Lordship. That is the last order, Your Lordship, in my, before filing of this case,
Page number?
33, 6/10/2023. Still is going on by taking adjournment by the opposite party defendant.
No, after that 23, on how many dates, what has happened? Unless you bring it
Record, sir.
to the record, how this court will issue directions to trial court?
Lordship,
Without knowing anything, how we
Lordship,
can,
I procured a certified copy on 2/6/2025, Your Lordship.
you bring those on record, up-to-date orders. So that unless we go through
29/4, I have a procured, if Lordship permit me, 29/4/2025 is the
no,
last.
Mr.
I will file an additional affidavit and why.
You have to bring that on
Record.
record. So that this
Present
court-
status of the case can be.
court has to come to a conclusion that suit is not progressing properly, only then a direction may be issued.
Got
Heard. Dr. B. N. Gogoi, learned counsel for the petitioner, who submits that he may be allowed to file an additional affidavit to bring on record the up-to-date status of the, bring on record various orders passed by the trial court in title suit number 33/2021 and up-to-date status of the said suit, which would be necessary for consideration of the instant CRPIO. The prayer is allowed. When?
Yes,
Let this matter be listed.
date may be fixed.
The date of 8th of January.
Item 5.
The routine order is at page 23. Petitioner has claimant filed one application claiming compensation under MB Act Lordship. And during pendency of this suit Lordship, this order was passed. Page 23. May I read Lordship?
Yes.
Claimant and opposite party number 1 are represented through their engaged learned counsel. Today is fixed for SRWS of OP number 2 and 3. None appeared for the OP number 2 and 3. Nor the claimant side has submitted any proof of service in respect of OP number 2 and 3. Peruse the case record. It appears that the claimant side has not taken any steps upon OP number 2 and 3 in compliance with our last order dated so and so. Under the above, it appears to me that the claimant side, despite availing several opportunities, has failed to take proper steps upon opposite party number 2 and 3. Hence, the case of claimant is dismissed in respect of OP number 2 and 3. So only in respect of OP number 2 and 3, claim petition was dismissed. And but in fact, if your lordship pages page 23, that is the previous page.
No, we are on 23 only.
Yes, lordship, kindly see page 22. These are the copies lordship will find top portion also. This is the certified copy. We have already submitted to the bench assistant about this taking steps lordship. And the track document was also submitted that your lordship will find page 24. Those were already delivered to the opposite side lordship, but that was not taken into consideration. And it was delivered on 22/8/2022, page 24, your lordship will find. And similarly, lordship, that regarding other.
Whether, have you not placed these documents before the
Yes,
tribunal?
these were placed before the lordship tribunal, and in fact, these are the certified copies. I have obtained the certified, these are not,
Then,
lordship will find page 22. This is the certified copy. We
but
applied for it and thereafter these were provided to us.
when it was sent,
It was sent on 19/9/22, prior to that lordship. On the, after filing claim petition, there was direction to take steps. I have taken steps on lordship, insurance company also, that page 22, third column, your lordship will get, that is the Oriental Bongaigaon division. They appear. Others also lordship service complete. But that was not taken into consideration. So at this stage, my prayer before your lordship is that order may be set and the tribunal may be directed to verify from the records lordship and pass appropriate orders.
no, in para 3 of the impugn order,
Lordship.
none appeared for so and so. The claimant side has submitted, nor the claimant side has submitted any proof of service.
That is the case, lordship. We have submitted, but that was not placed before the court by the bench assistant lordship. Because these are the certified copies. I have no, otherwise I would not have got this certified
Heard
copy.
Mr. A. Ahmed, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner Amina Khatun, alias Amina Khatun, impugning the order dated 11/12/2024, passed in MAC case number. Now, what is the status now?
The insurance company already appeared, they filed their WS lordship. But because of this, recently lordship, the court pointed out, then only it is came to the knowledge of the council that this order was passed, dismissing in respect of OP number 2 and 3 lordship.
Who is OP number 2 and 3?
Driver and owner. That claim petition your lordship will get page 10.
Impugning the order dated 11/12/2024, passed by the Motor Accident Claims Tribunal, Gwalpara, in MAC case number 395/2022, whereby the case of the claimant against opposite party number 2 and 3, that is the owner and driver of the offending vehicle, was dismissed because of the failure of the petitioner to take steps for issuance of notice upon the said opposite parties. Learned counsel for the petitioner has submitted that the petitioner as claimant has filed the
he taken steps and that track consignment was also submitted to the bench. Your Lordship.
MSC case number. And has filed a claim petition under section 166 of the MB Act. For MB Act seeking compensation on account of injury sustained by her in a motor vehicular accident on 12/4/2022. Learned counsel for the petitioner submits that in the aforesaid MSC case, the petitioner was directed to take steps for issuance of notice upon the respondents, upon the opposite parties. And accordingly, petitioner has taken steps on 19/9/2022 for issuance of notice upon responding all the opposite parties by registered post with AD. He submits that though the postal receipts of the notices sent to his opposite party number 1 and 2, as well as the track consignment report of the aforesaid notices were submitted before the bench assistant of the Motor Accident Claims Tribunal, Goalpara, however, same was not taken into consideration, and the trial court and the Motor Accident Claims Tribunal, in the impugn order, has observed that the claimant side has failed to submit any proof of service in respect of respondent opposite party number 2 and 3, which is, according to learned counsel for the petitioner, factually incorrect. Learned counsel for the petitioner has, in support of his submission, submitted the certified copy of the postal receipts of notices sent to opposite party number 1 and 2 by registered post as annexure 3 in this case. He has also submitted the track consignment report of notices sent to this opposite party number 2 and 3 as annexure 5 in this case. On perusal of the aforesaid postal receipts, it appears that the notices were sent to respondent number to the opposite party number 2 and 3. When it was sent?
It was sent 19/9/22.
No. On 17/8.
17/8/22.
17/8/2022. It also appears on perusal of the postal track consignment report that on 22/8/2022, the said notices were delivered to the addressee. Stop. In view of the materials placed by the learned counsel for the petitioner before this court, the impugn order dated 11/12/2024 is not sustainable and accordingly set aside. The Motor Accident Claims Tribunal, Goalpara, is directed to consider the postal track consignment report as well as the postal receipts submitted by the present petitioner before it in respect of notices sent to respondent opposite party number 2 and 3 within bracket driver, owner and driver of the offending vehicle, and thereafter pass an appropriate order to that effect. This CRPIO is accordingly disposed of without issuing notice to the opposite parties.
Only thing is that Lordship, they are delivered on 22/8/2022 and Lordship 29/8/2022.
22A, they shown to be have delivered on 22/8/2022 and 29/8/2022 respectively. So,
Obliged.
Item 6.
Apologies for troubling you a lot with the same dispute, my lord, the second time. My lord, what has happened here, I'll be very brief, my lord. We will annex all the documents just as an abundant caution. The issue otherwise is small. My lord, will recollect there was a freeze, the petitioner is a part of a huge conglomerate, my lord.
yes,
And one
you
of
are part of Protect Group.
Yes. And then, my lord, one of the partners, my lord, took a hostile stand. He approached the banks with various allegations. Accounts were frozen. Thereafter, my lord, all partners, along with that complaining partner, went and said that we have no objection if a particular partner is allowed to operate and the accounts will defreeze. Then he again went back and again got the accounts frozen a second time, my lord, which is why we had to approach the Section 9 court, under Section 9 of the Arbitration and Conciliation Act. Now, if your lordship has page 100 for a moment.
Size of the brief. Page 100.
Page 100. It's part of that order which still holds the field.
Yes.
Now, page 100, paragraph 15, your lordship will find the ad interim order. Paragraph 15, my lord.
Yes.
An order of ad interim injunction to forthwith defreeze the current account number so-and-so of the petitioner number 1, firm held by the OP number 2 IndusInd Bank Ganeshpuri branch, and debit payment requests made concerning transactions of the said bank account prior to the date of freezing. Number 2 again is important. This was in respect of a particular current account, and second one is a broad direction, an injunction restraining the OP number 1 from taking any action or steps for
OP
closing.
number 1 is bank.
No, OP number 1 is the partner concerned, who had been insisting on a freezing.
What is his name?
Lokesh Anand Singh.
Okay.
An injunction to restrain the OP number 1 from taking any action, steps for closing, freezing of the transaction in the bank accounts of the petitioner number 1 firm, post defreezing of the said current account of the petitioner, and from taking any steps from freezing the accounts of any sister companies, subsidiaries, or parents companies, firms of the petitioner. So 2 specific direction that the account should be defreezed, and there should be a restraining order restraining him from taking any steps whatsoever to sort of defreeze the accounts again, freeze the accounts again. Now, my lord, after passing of the order, my lord, he filed one suit to again freeze the accounts. The trial court declined an order of ad interim injunction, primarily on the ground that the flat buyers would suffer.
What was the suit? Title suit number?
266.
Filed by Lokesh Singhal.
Yes, yes.
Okay.
He also approached
Where
the
ad interim injunction was rejected.
rejected.
He approached this court. This court again rejected.
Rejected.
Now matter is before the trial court again.
The matter is before the trial court again, and so far as Section 9 proceedings are concerned, he's already filed an application for vacating the order that I've just read. No orders have been passed vacating or modifying that order till today. In the meanwhile, he filed a third suit also, my lord. He filed a third suit, and there also no interim order was granted. Now, now, my lord, after this, when the order specifically says that you must not take any steps, my lord, first he had gone out
filing proceedings after proceedings to get the account frozen again. And simultaneously, my lord, he approaches the bank repeatedly, page 437 onwards, urging the bank to again freeze the accounts. Relentlessly, my lord, he keeps writing to the bank that KYC mandate is not clear, there is a fraud being played, etc. Please freeze the accounts again. The operation should be stopped. So this is in clear contempt of the second direction passed in that order, my lord. Ultimately, my lord, initially your lordship will recollect the bank stand was also that we should not seize sort of freeze operations of the account, but they succumbed to the pressure ultimately. And at page 454, they issued a letter that you get a no consent letter from all the partners. So naturally, the partners who've been repeatedly urging the account to be frozen will naturally not come forward, my lord. That gives them a handle, my lord. 454 is those letters, my lord.
Yes.
So we are asked to provide the following documents. The lordship will mark those series of documents, beneficial ownership declaration, not signed by all the partners. So naturally, he doesn't come forward for signing. And on that ground, they keep insisting that I get the declaration from all the partners. And eventually, my lord, at page 505, your lordship finds all the accounts, including RERA accounts, have again been frozen. The order of 1912-24 remains, my lord, notwithstanding that the bank has now again frozen the accounts. Page 508 is the list of accounts that are frozen.
Okay, now, why you are before this court?
My lord, because it's in contempt, my lord, because under section 10, my lord, your lordship has the power, because there are authorities which have suggested that section 9 proceedings are not akin to injunctions, so therefore violation will not arise. And there are others which have said that, notwithstanding that there could be other remedies, under section 10 of the Contempt of Courts Act, your lordship will treat a contempt of the subordinate court as a contempt of itself.
No, is there no other remedy against violation of 1912-2024 order?
My lord, even if there is, my lord, my submission.
What is the remedy?
My lord, 39(2)(a), my lord, there are divergent views, my lord. I could not
Yes.
find anything by our High Court or the Supreme Court, but most of them have said that section 9 is not akin to 39(1) and 2. So therefore, 39(2)(a) you cannot invoke, you must come in contempt.
Oh, where is that?
My lord, those are state High Court judgments, but I'll rely on a few Supreme Court judgments, my lord, which have said that even if that remedy is available, if the contempt is on the face of it, the courts will not refrain from coming to the aid. And in fact, judgments have also said, if I have understood the judgments correctly,
No, suppose you have other recourse, then why this court should invoke its jurisdiction?
because contempt is the powers to punish for
Under
contempt are-
39(2)(a),
First of all,
you will have same remedy.
Lord, if I may rely on Rana Narang, it was quoted in HSBC. This was one of the arguments made, and they said that ultimately, if it's contempt, even if the orders are executable otherwise, my lord, I did not get Rana Narang, but Rana Narang has been quoted in this HSBC, para 49.
49. Yes. Please read.
At this stage, a few decisions of this court on contempt proceeding under the Contempt of Courts Act are required to be referred to. In Ramanarang, after referring and taking into consideration the earlier decisions of this court in R&A Rita Markande versus Surjit Singh Arora and Bank of Baroda versus Sadruddin Hasan Daya, it is specifically observed and held by this court that the petitioner can execute the decree can have no bearing on the contempt committed by the respondent. In the said decision, this court also considered in detail the decision of this court in R&A, which has been relied upon by the learned senior advocate appearing for the respondents in the present case. Para 24 of the decision is as under. All decrees and orders are executable under the Civil Procedure Code. Consent decrees or orders are, of course, also executable, but merely because an order or decree is executable would not take away the court's jurisdiction to deal with a matter under the Act, provided the court is satisfied that the violation of the order or decree is such that if proved, it would warrant punishment under Section 13 of the Act on the ground that the contempt substantially interferes or tends substantially to interfere with the due course of justice. The decisions relied upon by the respondent themselves also, as we shall subsequently see. So these orders could be executable. There can be two views about it, my lord. But even if that is so, my lord, then also it will not take away the jurisdiction of the court under the Contempt of Courts Act, my lord. Now, your lordship will kindly appreciate, my lord, the court has the direction of the court is very clear. You will not take any action. So this is clear contempt, my lord. Secondly, your lordship will also mark that you have repeatedly gone on to courts, at least for 4 occasions, my lord, asking for a prayer to freeze the accounts. On all 4 occasions, you have been declined an ad interim relief, at least till date. After that, to sort of again pressurize the bank and to sort of persuade the bank to again freeze the account would be clearly in the teeth of the directions of that order of 19/12/2024, my lord. And lastly, my lord, the ramifications are very severe, my lord. Even your lordship's order has also said that the flat buyers should not be made to suffer, my lord. There are hundreds of flat buyers, my lord. And in fact, if your lordship sees one thing, I must point out, the accounts that are frozen are special escrow accounts under the RERA Act, my lord.
What are those accounts?
Lord, the list I have already shown at page 508, my lord.
So bank is also one of the contemner.
Bank is also one of the contemners because they closed not only the current account, which was specifically ordered to be released.
Okay, we will issue notice.
My lord, the implications are such that, my lord, the entire business transactions would sort of go off, my lord, because your lordship will mark 1 day's freezing of 8 accounts itself is severe damage to me, my lord. Secondly, my lord, I'll just show
Okay,
one.
we are issuing notice.
My lord, I have a prayer that the account should be forthwith directed to be.
But in contempt jurisdiction, unless we come to a finding that there is a contempt, that is your allegation only that.
True, my lord, but I'll show prima facie, my lord. If your lordship
For that
allows me-
relief, you have to go to that original court.
That is again another problem, my lord. We approach the court, my lord. We approached the court said, I will defreeze the current account. So far as other current accounts are concerned, we'll post it tomorrow, my lord. Next day, the presiding officer goes on transfer, my lord.
Then there will be someone else.
Someone else has joined, my lord. But your lordship will allow me 5 minutes, I'll just show
No,
few aspects.
in contempt jurisdiction, we will not grant any interim relief.
Your lordship permits me.
Sure.
No, this is the DTA versus Skipper Constructions, my lord. That was one of the arguments that were advanced, that contempt is only for punishing. Why should the court go any further? Now, para 17 onwards, if your lordship sees, from page 14.
Yes.
Just above the paragraph is the subheading, my lord. the contemner should not be allowed to enjoy or retain the fruits of his contempt. The principle that a contemner ought not to be permitted to enjoy and or keep the fruits of his contempt is well settled. In Muhammad Idris versus so-and-so, this court held held clearly that undergoing the punishment for contempt does not mean that the court is not entitled to give appropriate directions for remedying and rectifying the things done in violation of its orders. The petitioners had given an undertaking to the Bombay High Court. They acted in breach of it. A learned single judge held them guilty of contempt and imposed the sentence of 1 month's imprisonment. In addition thereto, the learned single judge made appropriate directions to remedy the breach of undertaking. It was contended before this court that the learned judge was not justified in giving the aforesaid directions in addition to punishing the petitioners for contempt. The argument was rejected, holding the single judge was quite right in giving appropriate directions to close the branch. The above principle has been applied in case of violation of orders of injunction issued by civil court. I need not in Clark versus Chatburn, Sir so-and-so observed, I did not cite authority for the proposition that it is of high importance that orders of the court should be obeyed. Willful disobedience to an order of the court is punishable as a contempt of court, and I feel no doubt that such disobedience may properly be described as being illegal. If by such disobedience, the persons enjoined claim that they have validly effected some change in the rights and liabilities of others, I cannot see why it should be said that although they are liable to penalties for contempt of court for doing what they did, nevertheless, those acts were validly done. Of course, if an act is done, it is not undone merely by pointing out that it was done in breach of the law. If a meeting is held in breach of an injunction, it cannot be said that the meeting has not been held. But the legal consequences of what has been done in breach of the law may plainly be very much affected by the illegality. It seems to me on principle that those who defy a prohibition ought not to be able to claim that the fruits of their defiance are good or not tainted by the illegality that produced them. If I skip over to para 20, my lord, in Sujit Pal, a division bench of the Calcutta High Court has taken the same view. There, the defendant forcibly dispossessed the plaintiff in violation of the order of injunction and took possession of the property. The court directed restoration of possession to the plaintiff with the aid of police. The court observed that no technicality can prevent the court from doing justice in exercise of its inherent powers. It held that object of 2A39 will be fulfilled only where such mandatory direction is given for mandatory restoration of possession to the aggrieved party. This was necessary. It is observed to prevent the abuse of process of law. There is no doubt that this salutary principle has to be applied and given effect to by this court. If necessary, by overruling, your lordship will mark the word, by overruling any procedural or other technical objection. Article 129 is a constitutional power and exercised in tandem with 142. All objections should give away. Now, my lord, I must point out a few more aspects, my lord, very quickly, my lord. In the second freezing, my lord, the bank made a clear observation that the RERA account should not be frozen. I'm only freezing the other accounts. There's a reason for that. Now, these RERA accounts are special accounts where the money of the flat buyers are deposited. Now, this money cannot even be taken out beyond a particular capping without the sanction of authorized engineers. So, and now if these accounts are, in fact, some states have also said that there should not be any lien or attachment to such accounts because it primarily concerns the money of those flat buyers. These are statutory accounts maintained under Section 4 of the RERA Act. Now, page 57, if your lordship sees. 57. The decision of DTA was subsequently again principles were reiterated. I'll come back to them. But before that, if I may show one thing. Page 57, Manoj. 56. This is the second freezing by the bank. They froze the current account, but they did not freeze the RERA account. The reason being the first paragraph. However, for the accounts mentioned at serial number 2, 3, 4, and 5, as the said accounts were opened under the RERA regulation, debit freeze cannot be marked without court order. Now, they themselves acknowledge that RERA accounts are special accounts, so therefore we cannot freeze them without court orders. Today, there are court orders sort of implying that no account should be frozen, but they've frozen all of it. And what can happen, my lord, if the transactions would be in black and white in any case. If your lordship directs me, I can produce periodical accounts of every penny that is transacted, my lord. And in fact, if your lordship sees the RERA Act for a moment, lord.
You have otherwise approached the court which issued the restraint order informing that there
Correct.
has been a violation.
Correct. I have filed an application. I had to file a fresh section, I mean, in that same proceeding, but that is again was not taken up on the following day.
When it is fixed.
It is perhaps fixed on the last working day, my lord. So that is another example because every day, ultimately, a new presiding officer has joined in the meantime. I must inform the court, but the officer concerned would also require time to sort of consider the object. That's a practical difficulty which I'm now. Now what happens here is, my lord, he already achieves. Now the principle is technicality aside, my lord, principle is one who's already violated the order should not be allowed to reap benefits out of it. Now, that was the basic idea, my lord. Now that he's violated the order, he sort of limits transactions for a month or two. He's achieved what he wants, my lord. Thereafter, even if there's a defreezing, the damage is already done. Therefore, it violates that principle that he should not be allowed to take benefit of his own wrongdoing. That too in the teeth of the directions in 1912-24. 1912-24 was very clear. My lord.
Where is the application which you have filed before the?
Page 510.
5?
10. 510.
After freezing of the account again, you have filed this application.
Yes.
And this is listed when?
This is on the last day, you know, 19 or
Where is the order?
well, on page 521.
Notices have been issued. 412. It is fixed on 412.
That has been the presiding officer was transferred, so it was not.
Then next.
Next is 19th in all probability. I'll just check.
No, this matter is pending before.
True, my lord. I'll withdraw this.
No.
My lord, because time is of essence. That is why.
No, you can appear before the said trial court and pray. Considering your urgency, you can pray for preponing the dates. But for this court to give an interim direction, it has to come to a finding first that there has been a contempt.
That otherwise is on the face of it, my lord. And
No, that
secondly, my
is
lord,
your allegation only.
true, my lord.
Unless we issue notice and if we come to a finding, they rectify the.
If I may argue a little on the balance, my lord. I have been operating it for so
No, you
long.
have one forum available before you.
True, my lord, which is why I would have relied on the just relied on the judgment which have said that notwithstanding that there could be forums, this
No,
concerns
but
majesty of the court, my lord.
yes, for that court has to come to a finding that there has been the judgment which you are relying.
Right.
In that
I totally understand. my
first
lord.
he was punished
He was punished.
and thereafter he gave remedial order.
Right.
But for that, a finding has to be there that there has been. So now we are issuing only notice.
My lord, in that case, my lord, may I pray for a direction to the trial court to positively consider my prayer on that day?
No, we give you an liberty to make a prayer before the trial court, considering the urgency to expeditiously decide that issue. You can make a prayer before the trial court.
Again, but if there's a direction, ultimately the stakeholders will suffer.
Heard Mr. B.D. Deka, learned counsel for the petitioner. This application under section 10 of the Contempts of Courts Act, read with rule 3 of the Contempts of Court within bracket Guwahati High Court rules 1977, read with article 215 of the Constitution of India, has been filed by the petitioners alleging deliberate and willful violation of the order dated 9/12/2024, passed by the 19/12/2024, passed by the Commercial Court of London, Civil Judge Senior Division number 1 in number 1 Kamrup Metro in Miss Arbitration case number 205/2024. Learned counsel for the petitioner has submitted that the Miss Arbitration case number 205/2024 was instituted on the basis of an application filed by the petitioner under section 9 of the Arbitration and Conciliation Act, seeking injunction seeking the relief of an injunction against the opposite parties, including the present contemners. Stop. In the said arbitration case, by order dated 19/12/2025, the Commercial Court of London, Civil Judge Senior Division number 1, directed the opposite parties to defreeze the current account number 201019835579 of the petitioner number 1 firm. The said account was held by the said account was in the Indus Bank Ganeshguri branch. Stop. Further, an direction was also issued to the who was the OP number 1?
Lokesh Anand Singh.
Direction was also
Container number 2 here.
To the contemner number 2 within bracket opposite party number 1 in the said arbitration case, bracket close, from by restraining him from taking any actions, steps for closing/freezing of the transaction of the bank accounts of the petitioner number 1, petitioner number 1 firm, post defreezing of the said account, and from taking any steps for defreezing of accounts of any of the sister companies, subsidiaries, or the parent companies or firm of the petitioner. Learned counsel for the petitioner has submitted that the opposite parties in the misarbitration case
They appeared
appeared and filed objection,
along with application for vacating the.
and that was decided.
No.
Pending. The opposite parties appeared before the court in misarbitration case number 205/2024 and filed an application for vacating the injunction order, an order of defreezing of the bank account passed by the court by its order dated 19/12/2024. However, the said application is still pending before the court and yet to be decided. And therefore, he submits that the injunction order dated 19/12/2024 is still in force. Learned counsel for the petitioner has further submitted that the petitioner has also filed a separate suit, that is title suit number 266/2025. No, not the petitioner.
Container number 2.
The contemner number 2 has also filed a separate title suit, which was registered as title suit number 266/2025. And whereby an ad interim injunction was prayed for. What relief you prayed in that suit?
They
What relief they
They
prayed?
prayed for, again, for asking the bank to sort of
Mandatory.
for the all the other firms of the conglomerate.
Pray, kili, last. Ad interim mandatory injunction was prayed for, directing the contemner bank to freeze the
Account.
accounts of the various entities of Protect Group company held by the said bank. However, the trial court declined to issue any ad interim injunction and issued notice to the present petitioner. Stop. He further submits that being aggrieved with the aforesaid order of declining to issue any ad interim injunction, the opposite party contemner approached this court by filing a CRP,
FAO
by filing an FAO number which was registered as
31 of 25.
31 of 2025. Stop. Learned counsel for the petitioner submits that in the said first appeal against order also, this court, the said FAO was dismissed by the order, by
10/11.
by order dated
10/11/2020.
10/11/2025 by this court, directing the trial court to decide the injunction application after hearing both the sides. Stop. Learned counsel for the petitioner has submitted that in spite of the specific directions by the Commercial Court of Learned Civil Justice Senior Division number 1 Kamrup Metro in misarbitration case number 205/2024, the petitioner number 2, no, the contemner number 2 has again approached the contemner number 1 bank and prayed for. Where is that letter?
The series of letters,
What is 437?
439, he says, well, page 439, he says that banking operations become, bank accounts should remain inoperable. And he cites judgments, page 439, second paragraph.
In the last line. And prayed for re-verification of the KYC. And during the process of re-verification, prayed for what is the prayer for? The freezing?
Lord, he doesn't say freezing. If
What he
you're-
says?
And if not done as per RBI KYC regulation, the bank accounts will remain inoperable. Now, again, on this
And prays for
442, again, he says not to operate. Continue. Four 42. First paragraph. And further ask the bank not to continue operating the bank accounts with only so and so being the sole authorized signatory. So in essence,
and prayed for and asked the bank not to operate the bank accounts of the Protect Group of companies only on the basis of authorization given by other partners to Shri Manoj Kumar Jalal till the re-verification of KYC is done. Stop. He submits that accordingly. Where is the freezing order?
freezing the text messages, page 505.
Accordingly, the contempt number one bank, in spite of the clear restraining order by the commercial court in misarbitration case number 205/2005, had freezed. Where is the freezing order?
The text messages at page 505.
Freeze all the accounts.
Yes, a series of accounts.
All the accounts of the Protect Groups of company
No, not all, my lord. Eight bank accounts.
in
Eight number
eight numbers of bank accounts of only Pride Realty
of Pride Realty and another firm, my lord. So we are concerned only with Pride Realty sensitive.
of the
Petitioner.
petitioner's firm. It is a firm,
It's a firm.
partnership,
Partnership.
petitioner's firm. Learned counsel for the petitioner has submitted that the petitioner, when it was frozen,
1/12/2025. First of December.
petitioner firm on 1/12/2025. So, learned counsel for the petitioner has submitted that the petitioners have immediately approached the Commercial Court of Learned Civil Judge Senior Division number 1 in misarbitration case number 205/2024 and filed another application under section 9 of the Arbitration and Conciliation Act, bringing to the notice of the court the violation of its order by the present contemners and seeking for an appropriate directions from the said court. Learned counsel for the petitioner submits that the said application was posted for consideration on 4/12/2025. 4/12
3/12, my lord, it was considered, it was posted next on 4/12.
posted on 4/12. However, on that day, the presiding officer got transferred and the matter is now posted
17/12.
on 17/12/2024. 2025. Stop. Learned counsel for the petitioner has submitted that there has been a clear and willful, there has been that it is a clear case of willful disobedience of the order of the commercial court dated
19/12/2024.
19/12/2024, passed in misarbitration case number
205.
205/2024. And therefore it is a fit case to invoke this court's contempt jurisdiction. He further submits that since even the RERA account, which involves the money of this stake, money of the
Flat buyers,
flat
allottees.
flat allottees are involved, has been freezed. And therefore, immediate appropriate directions may be issued to the bank to defreeze the said account. Stop. Issue notice to the contemners. The petitioner shall take steps for issuance of notice upon the contemners by speed post as well as by usual mode within 3 days from the date. When can we fix? January.
Any date,
Putul date diyo.
Okay.
Within 3 days from the date of this order. Returnable on 20th of January 2026. This court is, however, not inclined to issue any other direction regarding defreezing of the account at this stage, as the matter is already pending before the commercial court in MISJ case number 1128/2025 in connection with misarbitration case number 2024. Stop. Considering the urgency of the matter involved, and also considering the fact that the stake of customers within bracket flat allottees are also involved in this case, the Commercial Court of Civil Judge Senior Division number 1 is directed to expeditiously dispose of the application under section 9 of the Arbitration Act, Arbitration and Conciliation Act 1996, filed by the present petitioner in MISJ case number 1128/2025 as expeditiously as possible. You can file a
My lord, may not say the section 9 application may be misconstrued as the entire 9.
Because then it'll be a
No,
huge
in this new miss case,
new mistake, new mistake.
section 9 in miss case number 1128.
One.
1128. As expeditiously as possible. Least accordingly.
Can it be, it's not just taking that in Jalmus, that it should be taken up for consideration on that particular day, the prayer in miss case 1128.
Okay. No, we don't know whether the other side has appeared or not.
Other side has been appearing throughout. And it's in that same proceeding.
की लिख ले last name. They directed to make all endeavors to dispose of the said application as regards the prayer for issuance of direction to the opposite party for defreezing of the said account on the next date fixed, that is on 17/12/2024, 2025, list accordingly.
Deeply obliged.
Lordship, kindly pass over the matter for time being, Lordship. My senior counsel is in, on court number 10. Maybe at 2 p.m.
What is the matter?
Pardon, Lordship, they have challenged the.
Motion, okay, at two. At two.
Item 9. It is your Lordship. Your Lordship, this appeal has been filed under section 23 under the Railway Claims Tribunal Act 19.
What is your name?
Your Lordship, A. Dev on behalf of the.
Heard Mr. A. Dev, learned counsel for the appellant. This appeal under section 23 of the Railway Claims Tribunal Act 1987 has been filed by the appellant, Messrs. Mangal Murthy Vanijya, impugning the judgment and order dated 28/2025 passed by the Railway Claims Tribunal Guwahati in original application number within bracket Roman 3/GHY/35/2023, whereby your claim was dismissed. Whereby the claim of the present appellant was dismissed. Issue notice to the respondent. Since the learned DSGY GI has already been served with the notice of this appeal. No formal note, already been served with the memo of the appeal. No formal notice need to be issued to the respondents. This appeal is admitted. Call for the records of original application from the Railway Claims Tribunal. The registry to take steps for requisitioning the records. List this matter after 4 weeks on receipt of the records of the original application.
Your Lordship, similar orders may pass in item number 10.
Item number?
Yeah.
Same order, OA number below.
Obliged. Item 11.
Caveat is there. Caveat is there.
Yes, sir.
Who is for the caveat? Yes. What is the matter?
Initially, learned trial court granted injunction order in my favor. Thereafter, Lordship, the appellate court interfere with the discretionary injunction power without showing arbitrariness and perversity beyond under 43 Rule 1. That is why I have preferred this revision.
Before my
petition.
learned friend starts, I want to raise a objection to the maintainability. He filed this petition under Article 227. That is not maintainable. That does not lie.
No alternative remedy is there. That is why 227.
Why it is
applicable.
not maintainable?
Because it is an order of appellate order against the section 115 lies.
Against?
Against the order of an appellate court in filed under order 41 Rule 3. Revision under section 115 lies. Not to
Yes.
No, Lordship. 227 lies. There are various judgment. I do not know that question will raise. This matter is listed for third time. Is before your honor from very first day as caveated.
That question I can raise at any time before finally deciding.
No, but it has to,
No, Lordship.
question of maintainability
earlier-
has to be raised at the first instance.
May see the on the very first occasion.
Okay, Mr. Ali, you come prepared. We'll fix this matter.
I will place judgment in this regard. Since
On the
matter is
question.
connection with injunction, it is very urgent.
It
Since
was
they are-
filed in the month of June. It was filed in the month of June, and now they are pressing to the, it is urgent, that's unnecessary, so.
Matter is listed as many as 3-4 times. Lordship. Till then.
Whether all the opposite parties are before this court.
Yes.
I've taken about 2, Lordship. I will satisfy in that point.
No, no, not at two. Today we have lesser time. Two, we have already fixed matter. And today court is rising
Monday,
earlier. Monday or Tuesday we may fix.
Also, one more thing, we filed a petition for rejection of claim in the trial court. It is fixed for order on 6 January. So this matter will be taken up after that. If that petition is allowed, then this hearing on this will be fruitless.
I will, that ground is there. Definitely I will satisfy your Lordship.
Okay, we'll hear on. Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. R. Sharma, learned counsel for respondent, who raised a question of maintainability of this application under Article 227 of the Constitution of India. He submits that impugn order was passed by the trial court under Order 43 Rule 1R of the Code of Civil Procedure, and hence an application under Section 115 of the CPC lies in this case, and not an application under 227. Stop. Learned counsel for the petitioner, on the other hand, submits that this is for the 4th time this matter is listed before this court, and the petitioner has raised the question of maintainability for the first time, and hence, first time today, and hence he has prayed for some time to satisfy this court regarding maintainability of the petition filed by him. The prayer is allowed. Let this matter be listed again on Tuesday, 16/12.
But my second submission is that since the petition is pending there in the.
On
court, so after-
Tuesday,
After 6th of January, because vacation is coming.
no, first let us decide the maintainability. Tuesday.
On Tuesday, 16, I have some difficulty, Lordship. I shall be away from Guwahati. So,
15.
17th or-
Happy Monday.
Okay,
So, was it-
17.
Yes, Lordship, 17.
17.
Obliged.
Practical, Lordship. This is an appeal against a quantum of complaint.
Willing to deposit 50%.
Heard Mr. R. Goswami, learned counsel for the appellant. This appeal under section 173 of Motor Vehicle Act has been preferred by the appellant insurance company, impugning the judgment and award dated 3/8/2024 passed by the Motor Accident Claims Tribunal Sonitpur in MAC case number 121/2022, whereby the appellant was directed to pay a compensation amount of rupees 21,88,000 to the claimant respondents. Stop. Learned counsel for the appellant has submitted that the appellant is mainly aggrieved with the quantum of the compensation award to the claimant respondent. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order.
Court has already filed Okada.
7 days from the date of this order, within returnable after 4 weeks. Since respondent number 3 and 4 have already appeared by engaging a counsel in this appeal, no formal notice need to be issued to the said respondent. Let the records of the MAC case number 121/2022 be called for from the Motor Accident Claims Tribunal, Sonitpur, registry to take steps for requisitioning the records. List accordingly. In in interlocutory application, heard Mr. R. Goswami, learned counsel for the applicant insurance company. This application under Order 41 Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicant in connection with MAC appeal number 553/2024, praying for stay of execution of the impugned judgment and award dated 3/8/2024 passed by the Motor Accident Claims Tribunal Sonitpur in MAC case number 121/2022. Stop. Learned counsel for the applicant has submitted that the connected MAC appeal number 553/2023-2024 has already been admitted by this court, and notices to the respondent have also been issued. He further submits that the insurance company is ready to deposit 50% of the awarded amount before the registry of this court as a condition of grant of stay of the impugned judgment and decree during the pendency of the connected MAC appeal. Stop. Considering the submissions made by learned counsel for the applicant, this interlocutory application is disposed of without issuing notice to the respondents. Stop. by directing that during the pendency of the connected MAC appeal number 553/2025, the execution of the impugned judgment and award dated 3/8/2024 passed by the Motor Accident Claims Tribunal Sonitpur in MAC case number 121/2022 shall remain stayed subject to payment of subject to deposit of 50% of the awarded amount. Within bracket लिखिबो total awarded amount is of rupees 21,88,000 bracket before the registry of this court. The applicant insurance company shall deposit the 50% aforesaid 50% sum of the awarded amount within how many days?
4 weeks.
Within 4 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Yeah, please.
Yes.
My lord, this is against the rejection of injunction order, my lord. Appellant before your lordship is the plaintiff, my lord. The appellant has filed one suit for a specific performance of contract as well as paying other release, my lord. Along with that suit, my lord, an application under Order 39, Rule 1 and 2 was filed for only paying a limited prayer that no third party right may be created, my lord, during the pendency of the suit. Initially, a status quo was guaranteed, but thereafter, my lord, the other side, the defendant had thereafter, in defendant entered appearance, they have filed written statement, and after hearing the parties, my application for injunction was rejected, mainly on the ground that, my lord, this is a suit for a specific performance of contract, and the plaintiff can be compensated in terms of the money, my lord. I'm against that order, my lord.
Now, what is the wrong in that order?
My lord, my submission is that, my lord, although that part is there that he can be compensated, but the thing is that, my lord, the consideration is about 68 lakh and already 30 lakhs is paid. So I have prayed in the alternative relief, my lord, 30 lakhs plus 68 lakhs. So if the land is sold to any other person, then it is very difficult to recover that amount of money. So I'm not praying any other thing, only no third party right may be created, my lord. And my lord, the case is that, my lord, they are admitting that there is agreement, everything they are admitting, even the payment of the advance they are admitting. The only thing is that, my lord, the wife of the defendant number 1, who is the, my lord, seller, has filed one objection before the DC by saying that he cannot sell the land because they have invested earlier the huge amount in that land. My lord,
Where is the impugned order?
impugned order starts from page 55. Page 55, my lord, then let me directly come to page 60, my lord. The finding of the court, my lord.
Yes,
Page 60. May I read, my lord?
yes.
I'm reading from paragraph 8, prima facie case, my lord. Is there prima facie case in favor of the petitioners? I have gone through the entire materials on record. The petitioners have stated that the petitioners have entered into an agreement with opposite party, Sri Ajay Kumar Gogoi, for purchasing the land scheduled in Schedule A and B of the plaint and fixed the total consideration at rupees 68 lakh. On the same day, the petitioners have paid an advance amount of rupees 30 lakh to the opposite party. But the opposite party has not obtained the land sale permission as per the agreement entered between both of the parties. Under exchanging part of Schedule A land with the land of TDA for connecting the Schedule A land with the road. The area of Schedule A land remains same, but the tag number and patta number of Schedule A land has been changed, which is described in Schedule A1.
Now the opposite party has refused to sell the schedule A1 land and dependent number 2. The wife of the opposite party has filed an objection against the issuance of NOC in respect of the schedule A1 land. The petitioners are ready and willing to get sell deed in respect of schedule B and schedule A1 land by paying the balance consideration amount of rupees 38 lakh. The wife of the opposite party has no right to file objection as she is not the party to the agreement between the petitioner and the opposite party. Now there is apprehension that the opposite party may sell the suit land to the third party. So the petitioners have filed the present case, praying for temporary injunction restraining the opposite party, their agents, attorney, etc., from transferring, selling, or alienating the schedule B and schedule A1 land. It appears that the opposite party has admitted that he entered into an agreement with the petitioners to sell the schedule A land, schedule A and schedule B land at 68 lakh, an advance amount of rupees 30 lakh was paid to the opposite party. The contention of the opposite party is that the opposite party entered into the agreement due to urgent need of money, but the matter was delayed by the petitioners. Now the DAG and Patta numbers of the schedule A land has been changed and schedule A1 land is not in the agreement between the parties. It appears from the opposite facts and circumstances of the case that as the opposite party is not denying the execution of the agreement between the parties and raised objection in respect of schedule A1 land, which is also a part of the schedule A land, and the petitioners are claiming that the wife of the opposite party has no right to file objection as she is not the party of the agreement. There is a prima facie case in the instant petition and this point is answered in affirmative. Next matter.
Now, why there is prima facie case? You are apprehending that he may sell that.
Yes.
On what is the basis of that apprehension?
My lord, I have given the specific statement that after filing of the suit, he will say, he will try to dispose of the suit land.
That, no, what is the basis of that? Prima facie case in respect of the injunction is not as regards the main suit. The trial court has erred in that, holding that there is a prima facie case on that count. Prima facie case with respect of grant of injunction. Yeah. Prima facie case for this case relating to specific performance of contract is there. But for grant of injunction, court is not denying that you have a prima facie case as regards to your prayer in the main suit. That is for specific performance of contract. But your injunction application is based entirely on the premises that you are apprehending that he may sell it. There has to be some basis of that apprehension. He must have applied for sale permission or some talk is going on between some parties. Mere stating that he may sell it does not constitute a prima facie case. You have to show something which caused apprehension in your mind that he may sell it. Some talk is going on between third party, some agreement was executed. What is there to show the basis of your apprehension?
My submission is that, my lord, although there is no specific averment in the plaint or in the injunction application, my lord, but the statements are there, my lord, that immediately on coming to know about the filing of the suit, he may sell the suit land, my lord. And my lord, the prima facie, with regard to prima facie case, my lord, my submission is that, my lord,
No,
agreement,
that is my question. That he may sell this suit land. What is the basis for this averment?
my lord, so far regard to averment, my lord, there is no specific averment.
Then you don't have a case.
My lord, my submission is that, my lord,
And where else? Okay. Why the trial court rejected the injunction? Denied the injunction? It held that prima facie case is there.
yes, but it
What is not there?
the court says that, my lord, since it can be compensated in terms of money, and therefore the injunction, the trial court has refused my injunction. My lord. That is in the balance of convenience and irreparable loss, my lord.
Is there any alternative remedy in the specific performance of contract suit. You have prayed for alternative remedy also
I
for
prayed.
return of the advance.
Yes, I for return as well as for compensation, my lord. Both these prayers are there. Yeah, alternatively, my lord. But the
So
main-
even if the land is sold, assuming that it is sold, you are entitled to the alternative remedy.
my submission is that, my lord, if land is sold, my lord, the huge amount, about 68 lakh is the consideration and 30 lakhs is the advance amount, my lord. It will, even if the court grants, it will come about 98 or some odd lakhs, my lord. So it will be very difficult to recover if the land is sold, my lord. And my lord, the wife has already filed the objection.
No, you will be recovering it from the defendant.
Yes, ma'am.
You will be selling land. Okay, okay. Now what is your submission?
My submission first is that, my lord, they are not denying the agreement, my lord. Even if lordship may see their written objection, my lord, they are admitting. If lordship may come to their written objection, my lord, that is at page 44.
Page number?
44, my lord. If it starts from page 44, if lordship may kindly write to page 45, my lord.
No, first you submit as to what is the infirmity or error in the impugned judgment.
My submission is that, my lord, that compensation part or the compensation by way of money. The court has held that since there is in the agreement also there is clause that if the agreement is not, my lord, sale deed is not executed, then he will be compensated in terms of money, as well as in the suit. There is an alternative player that if the specific performance of the contract is not granted, that he can be compensated in terms of money. Therefore, the court has held that since there is an alternative prayer in the both in the agreement for sale as well as in the prayer portion of the plaint, my lord. Therefore, the court has held that instead of granting the injunction, if the decree is granted in his favor, then he can be compensated in terms of the money, my lord. My submission in the agreement for sale also, my lord, the clause is there, but that is in alternative, my lord. That is just as a precautionary measure, my lord. That if that thing is not to materialize due to some reasons, my lord, there are conditions are also there, my lord, then that can be done. But my specific plea is that, my lord, I want that this sale deed to be executed, my lord, and there is no fault on my part, my lord. I am always ready and willing to pay, and my lord, agreement for sale says that, my lord, purchaser has to obtain the permission. He has not obtained the permission, my lord. And I have already paid the advance amount as agreed, and the rest amount is on the before the day of execution of the sale date, my lord. But he has not obtained the permission, and instead, my lord, his wife has filed objection, who is not a party to the agreement. She has filed objection that no, this my husband cannot sell his land, my lord. So after that only I have filed the suit, my lord. And in the meantime, my lord, this land value of the suit land is already, my lord, went up, my lord. So that's why they do not want to sell the suit land to me, my lord.
Yes, anything else?
Lord, if lordship may come to their written objection, my lord, page 44, it starts, if lordship may come to page 45. Page 45, my lord.
Yes.
My lord, paragraph 10, my lord. That the statements made in paragraph number 2(1) of the petition being matters of record as such, anything not borne out of the record is hereby denied in toto. The petitioners are required to prove the same in due legal manner. It is true that on 5/3/2011, an agreement to sale was made between the petitioners and opposite party number 1 in respect of Schedule A and Schedule B land, and total consideration was fixed at rupees 68 lakh only, and an amount of rupees 30 lakh only was paid by the petitioners to the opposite party number 1 as advance against the total consideration stated in the agreement for sale, that is Schedule A and Schedule B. Then lordship may kindly come to my lord, objection with regard to his wife, that is at page 48, my lord. Page 48, second paragraph, my lord.
Yes.
It is admitted that the opposite party number 2, she is the wife of my lord, opposite party number 1, had filed an objection petition on 9/3/2023 against the land sale permission of the land Schedule A
of the petition before the chairman, Tinsukia Development Authority Office, Tinsukia, for a genuine case. For a genuine cause, it is pertinent to mention herein that both the opposite parties constructed a steel structure with roof on top in the year 2017 over the Schedule A land with an intention to manufacture household utensils and other products under the name and style of Mr. So-and-so, and also got the electricity connection in the said steel structure, and a huge amount of spent by the opposite party number 1 and 2 amounting to rupees 10 lakh only for the construction of the steel set with modern furniture and fixtures, and also the required machines and other equipments were also installed thereat for starting the business in the said and running the said business. However, the petitioner number 2, on the way of executing the concerned agreement, requested the opposite party number 1 to dismantle the said and remove the machine, etc. Therefore, as he wanted to purchase the vacant land, and opposite party number 1 dismantled the said structures and removed all the machines, etc. Therefrom, on 15/3/2011, the foundation of the steel structure still appeared on Schedule A land. The dismantle of the steel structure was done by the opposite party number 1. So these are the objections, my lord. See has filed. My submission is that, my lord, opposite party number 2, who is the wife, my lord, she is not a party to the agreement. She is not a party to the agreement, my lord. So she do not have any right, my lord. And my lord, everything is admitted. I am ready and willing to, my lord, perform my part of the contract, my lord. There is nothing is that, my lord, I have not performed my part of the contract, and so therefore, my lord, the prima facie case, and my prayer is very limited, my lord. Only third party rights may not be created. That is my case.
Yes, Mr.
Regarding, we failed to obtain the permission, Milord, that we have denied. That we have stated in the yes objection also that we have given all the papers to him because the defendant, they stay in Jorhat and the land is in Tinsukia. So they being aged, Milord, they said that you take all steps for obtaining the permission from the authorities, and that he failed. Now they are blaming us that we have not obtained the permission. That your lordship will find that page.
No, but that is the subject matter of the main suit. We are considering whether the denial of injunction prayed for by the present petitioner.
No,
By
we have stated personally that we are not selling A land, and B land we were willing to sell it to him because they were a delay in obtaining the permission by themselves only. It was not our fault. That they are alleging now that we have failed to obtain permission and there was delays. And since there is a prayer for the money also, advance money in the suit, Milord, in the plaint, we are ready and willing to refund back the money, Milord. Yes, at page 24, there is a prayer regarding 30 lakhs. That we are willing to pay. If he wants to get it, Milord, we can pay it now itself, with interest.
That is not the matter before this court.
That is true, Milord. That is also part of this plain. But that we have denied not to sell the A land because in A land, Milord, there were some differences in the schedule with the agreement also, because there are some reallotments by the development authority, and for that purpose that was there, that you also may see also in schedule. And
You have filed any objection in this case?
I have stated, Milord, in that objection that we are ready and willing to hear that, and there is an assurance also that we will not arbitrary then to any other person.
Okay.
So there may not be any apprehension on that, my lord, of selling it to other persons on profit or, and he may be at loss.
Appeal dismiss. I'll pass reason order in chamber.
All right.
Item 47.
My lordship, I am on VC, my lord.
Yes.
My lord, we filed a suit, my lord, with an injunction application. By an impugn order, the learned court, though said that.
Now this VC has become AC.
Okay, my lord. I am sorry, my lord, I am not.
But you are audible, you can continue.
No, I'm just opening, my lord. I wouldn't like to disturb this honorable court, my lord, so just opening. So therefore, by an impugn order, my lord, the learned court, though heard the matter at length, instead of passing any effective order, issue notice to the other party. That's amounts to a refusal, my lord.
When is the date fixed next?
That's the important issue, my lord. That they fix the matter on 19th of January, after 49 days of passing the order. So therefore, the urgency of granting or non-granting of injunction, that has been absolutely frustrated. And this is not the spirit of the law. Either you have to dispose the matter within 7 days or 15 days as per our High Court rules also, my lord. So what I pray before this honorable court, my lord, at this stage, because the learned court is in session of disposal of this matter, I may be protected. In fact, the injunction order, in fact, will help the other party, my lord. They hold the tea garden. I only pray that to maintain the status quo, they are operating the tea estate. I am not saying that you have to hand over the position, you something not operating the tea business, etc. I am only protecting the subject matter of the suit. I am saying not to act against prejudicial to the interest of the plaintiff, my lord. And that too is for a limited. So what I propose, my lord, if subject to the approval of this honorable court, my lord, that let the matter be returned back to the remand to the trial court, and
No, the question of remand does not arise. Matter is already there before the trial court.
Yes, absolutely, my lord. So therefore, the matter may be expeditiously disposed of, and till that period, my lord, I may be protected. That's only the limited submission. And I will satisfy, my lord, that we have a very, very well-established case for granting an injunction, or in other words, the status quo order.
Okay, what is your case?
My lord.
Where is the impugn order?
Impugn order is page 235, last page, my lord. We moved the matter on 20th of 11, my lord, 20th of November. After 3 days, the learned court has passed the order, saying that hard learned counsel for the petitioner also perused the amendments made in the petition, plain documents, everything the learned court has gone through. Upon considering all, this court deemed it free to hear all the parties. There is no all the parties, there is only one party. Before granting temporary injunction, now lordship will find that the fixing 19/1/2025 for service report and written objection. So even 19/1, my lord, the matter has not been fixed for hearing or consideration of the interim prayer. After 49 days, my lord, the matter has been fixed. Absolutely, palpably, my lord, this order is bad in law.
Where is your injunction application?
Lordship. Lordship will find my prayer, injunction prayer 206, it starts from, my lord, 151. I'm sorry, Your Lordship. It starts from 191, yes, 191. And prayer is at 206. 216.
Yes, what is your case?
My case is, my lord, that we entered into an memorandum of understanding to sell the tea estate.
Who are you?
I am the owner of the tea. I am the company, my lord, own this tea estate.
Okay.
Now, thereafter, my lord, as per the statutory
And
norms,
who is the respondent?
respondent is a company who intended to buy the property.
Which tea state? Which
It's a-
property?
It's a Kubang tea estate, my lord, situated in the district of Tingshukia. Now, this MU, Lordship will find at page 23, at a consideration amount of rupees 51 lakhs, 51 crores, 51 lakhs. We have decided to purchase they decided to purchase the property. And thereafter, my lord, on some consideration and some negotiation held, and then it's the consideration amounts reduced to 49 crores, 1 lakh. Then what is important, my lord, in this case, that as per the norms to sell the tea estate, we have to obtain a permission to execute a deed of agreement and power of attorney from the government. And accordingly, an NOC was obtained. Lordship will find, kindly have a look at page 41.
Yes.
41. Lordship will find that the NOC was specifically said that the agreement to sale and the power of attorney will be valid for 1 year.
Okay.
Lordship will get it, this clause number 1. This agreement, this dated is 5/10/2023. The agreement for sale and power of attorney shall have a validity for a period of 1 year from the date of registration. And said that within this, the proprietor of the tea garden shall apply for seeking no objection government such and such to the second within a 6 month from the date of registration of the agreement to sale. So therefore, meaning thereby, the agreement to sale and the power of attorney shall be valid for 1 year. And this agreement to sale, 2 agreement of sale executed in respect of the land building plans and fixed asset. And both the agreements are dated 16/11/2023. Lordship will find it page 43.
No, the agreement of sale was between you and Kobong Tea.
Yes, Tea Company Private Limited, the purchase.
And which tea state you agreed to sell?
Kubang Tea Estate. This company, Kubang Tea Estate.
How it can be Kobong Tea State? Kobong Tea State is the purchaser.
No, they formed a company in the name of Kubang Tea Estate Private Limited.
But Kobong Tea State belongs to you.
Yes, absolutely. And this subject matter, they choose the name, my lord. Some choose the name of Lord Rama or Saraswati. They choose the name of the tea estate itself.
Okay.
We having several tea estate among these. Now, Lordship is the kindly look that page 43 and 43 says that this agreement of sale that was executed on 16/11/2023. Lordship will find at page 44 the date of the agreement. Now, as per the NOC, my lord, this agreement to sale and the power of attorney would remain valid for a 1 year. So those expired is validity by dint of that period on 16/11/2024.
Yes.
So therefore, in fact, they run the tea estate now without any power of attorney, without any validity of the power of attorney and agreement to sale. Now we had time and again we requested them to get the sale deed registered and also settle some amount which due and payable by them.
No, T state is already handed over to them.
Yes, and we received the sale consideration amount. Now there was some dispute.
You have received the sale consideration amount.
Correct, my lord. Now
Entire.
there is a dispute, my lord, in respect of a balance sale consideration amount which we said 3.5 crores. They disputed that amount. Because lordship, we have already pointed out that the
No, suit is for why you filed the suit.
that's the issue, my lord. We file a suit for getting the sale deed registered by them within a certain period that we play before the court within a 3 months or the time the court may fixed. That's one issue. The second issue is that to get the sale deed registered by paying the balance sale consideration amount, which we claim 3.5 crores. They deny it. They said the entire sale consideration was paid. That is a disputed fact that has to be proved in the trial.
So main dispute is receipt of balance
Sale consideration amount and also some dues of the hospital bill, etc., labor quarter, etc. So there's a very nominal amount, 19 lakhs something.
Otherwise, the property is with the possession of
Yes,
the.
yes, absolutely. Absolutely. Now what the problem is that already the sale agreement and the power of attorney now expired, my lord, by dint of that NOC.
Okay.
Now there is no validity. And they also unauthorizedly occupy some portion of the land. That is also a disputed question. They say no. We say you encroached. Now what we pray, my lord, that they are now going to transfer some portion of the land and the entire land with somebody. The negotiation has been. There is a news that spread over in the market and that we have received. Now we are only concerned that to get the sale deed registered within a time frame, my lord. Until that period, they should not do anything prejudicial to the interest of the plaintiff petitioner. That's the only issue, simple issue in this suit. And get the money. What would be that decided by the court? It will be settled and negotiated by a mediation also, my lord. Because what happened, my lord, their occupation now is illegal. That agreement of sale and the power of attorney now invalid. Now if they transferred anything to a third party without
No, how they can transfer? The sale deed is yet to be registered.
Now the possession may be transferred, my lord. This is
On
a
what
company, they
basis?
may transfer their share to any third party.
On what basis you are apprehending that they may transfer?
No, our apprehension is by their conduct only.
Because
Their conduct is
case-
very apprehensive.
Trial court has fixed your case injunction application on 19
January,
1, 2026.
my lord.
So is there anything to show that in between 19 1, 2026 they will sell it?
Yeah, we filed the
Only
suit for
then you have a case for a ex parte ad interim injunction.
my lord. The only issue is we have filed a suit after corresponding so many letters and etc. etc. And when they denied our claim, then only they denied our claim in December 2020. If you will find page 149, they denied our claim. Now thereafter, having no alternative, you file this suit. because I am happy, my lord, that on caveator, the opposite party has been appeared. The only undertaking that they will not do anything which is prejudicial to the interest of the plaintiff, my lord. That's only thing. And status quo to the scheduled property is in fact also benefited to them also. Them also.
Mr. Datta,
My lord.
to get an ex parte ad interim injunction,
My
you have to satisfy that there is a possibility that before the next date fixed,
I understand, my lord.
the suit will become infructuous. They will do something before that date.
I understand, my lord.
What is there to show that?
But lordship also appreciate there is very difficulty, my lord, to show any cogent evidence before the court. Lordship will also appreciate. Lordship dealing with so many cases.
No, it is selling of a tea state. They
Not a
cannot
setting.
show.
We are not only on that or lordship. It is a company. Company may sell his share to the third party also without knowing to anybody. Company may buy their board resolution, my lord. By their own they may sell. It cannot be publicized or advertised in a public domain, my lord. Now their occupation absolutely on record is illegal, my lord. And unless the sale deed is executed, they are having no title over the property.
In your injunction application, let us go to your injunction application.
My lord.
What is the ground stated by you to get an ex parte ad interim?
That's whatever I orally submitted.
How the issuance of notice will defeat the ends of justice in that case? In your case, what averment you have made?
This is a general statement I have made, my lord.
Para?
Lord, you will find para 9. This is the last paragraph, 215.
No, when you are seeking ad interim ex parte injunction, you have to make out a case for grant of ad interim ex parte injunction separately. That unless injunction is granted without issuing notice, your case will be defeated. No such statement.
I'm saying in a general terms, my lord. I'm
That-
saying in a general terms.
Is
But if
that
your
enough?
lordship posed a question very specific, lordship will find that it is very difficult to answer also. Because I am saying that my apprehension is, that's I'm only address, my lord.
No, my query is different. My query is, unless you make a averment in your application, that case is so urgent that unless notice is dispensed with without for
That I am saying, my lord, in a general terms.
For 215, paragraph number 9 and 213 onwards, the statements are there.
No, general statement. It is a general statement. You have to
I'm only
show the facts.
I'm only what I'm impressed with, what I would like to address, my lord, with all humility, that I'm describing the situation, what the circumstances for filing of the suit, my lord, and under what circumstances this suit is instituted, how the agreement become now infructuous, how their occupation is now illegal, and by doing so, when a party is in unauthorized occupation, my lord, of a property, he may do anything.
Now you
if-
have
if-
already received the consideration amount.
No, that's a disputed question. I'm
A part of it you have received.
yes, I'm still
part of
receiving 3.5 crores is a big amount. So therefore, if something happened, my lord, who will protect this multiplicity of litigation? Suppose, my lord, suppose that they transferred their share to another company. This company is constituted only for this Kubang name, my lord. No other activities. So therefore, if they transferred, then the multiplicity of litigation, my lord. I am only saying, my lord, that no acts to be prejudicial to the interest of the plaintiff. The very simple prayer. I am not saying that you should not stop the operation. You have to go out from the. I'm not saying any restrainment order against them. That's the issue, my lord. A very complicated situation we have filed this suit. Otherwise, why should we litigate the matter, my lord? I've received a substantial amount of the sale consideration. We transferred the position of the tea estate, etc., etc.
Yes. Yes, Mr.
Yes.
What is the name?
Ajay Das. I'm for the KVT.
Yes.
Lordship,
Are you going to dispose of the?
Lordship, first of all, the order as it is there. Now there was this order which was given, the ex parte order was given. The ex parte order was not given. Now, for whatever reasons the court had given, ultimately the opposite party, that is us, we are before the court. Whether it be here or because we are aware of the case, that there is a case pending. Now, my learned senior has said that this case is basically they are seeking for some kind of a relief where their rights needs to be protected. Now, their right needs to be protected is that they said that the possession is illegal. Why? The power of attorney has expired. So probably this here there is. I mean, we probably have not been instructed, but this is the 9 December power of attorney extension by the government. First of all, so the power of attorney has been extended. Secondly, there was the contention that was made by my learned senior counsel was that we had not executed the final.
No, what has been extended? NOC.
The power of attorney.
Not agreement to sale, my lord.
However, as the validity of the period of agreement sale and power of attorney has lapsed, the entity again has applied for extension of the validity on 8/5/25. Taking into account the fact that the entity has applied for registration of the conveyance deed and the process is presently ongoing, a further extension of the agreement for sale and power of attorney between APJ Limited and Khobang Tea Estate Private Limited is hereby granted until further approval of the government regarding the registration of the conveyance deed in respect of the Khobang Tea Estate Private Limited. So this has been extended. Now, why we are not able to execute? Because there were certain dues which they had not disclosed to us, and those dues had to be given, and this is a government notification. Now, that's why we are not able to execute it. 51 crores we have paid. So 51 crores was the amount fixed. 49 we have paid. 3 crores there is a dispute. Now, for an injunction order to be passed, whether it be ex parte or whether it be a full-fledged injunction order, the most important, whether it can be, it's irreparable, which cannot be compensated in terms of money. What is their claim? Their claim is that they will get whether the 3 crores they are entitled or not, that's their claim. Now that entitlement is submitted by them, it will be by way of an evidence. Whether these things happened, whether there was a liability on our part to give the 3.5 crores, whether they should get it or they should not get it, that all will be a part of the trial. Now, that is the second aspect of the matter. Further, the Lordship may just take I'm not filing. These things will be filed by if I file an objection. But just to show the prima facie that this case can be disposed of at this stage, let the proper hearing happen regarding the injunction before the trial court, where we'll file the objection, we'll show the papers. If the trial court comes to a finding, yes, these are the papers of the plaintiff, these are the papers of the respondent. Now, looking at both the papers, yes, some kind of a protection needs to be given. That would be executed at that stage. Now,
I'm not submitting any other paper. Lordship may just come to page 27 for a moment. Four pages I'll show, Lordship. Just 4 pages. This is the MOU for which enforcement they are seeking. In the main title suit, they are seeking for the enforcement of the MOU. Page 27, Lordship.
Yes.
Point number 15B only I'll just show.
Yes.
Lordship. The vendor shall provide full cooperation to the purchaser to facilitate for permission and
We
approve
will continue at 2.
at 2.
At 2.
I want to file a requisition letter, Lordship. Objection has been filed by the opposite party, but it hasn't been taken along with the record. Although in the last order, it was directed to the receipt to take along with the record. May be allowed to bring on record the objection.
39. Objection anybody.
For I. That's
Maybe, Your Lordship. But
Yes.
if I was showing page 27,
Page number?
27.
Yes.
His Lordship 15B.
Yes.
The vendor shall provide full cooperation to the purchaser to facilitate for permission and approval from government for transfer of leasehold rights of the land and execute and provide all documents and papers as may be requested by the purchaser from time to time. So this is based on the MOU part which had happened. Now, Lordship, may you please to come to page number 30.
Yes.
Lordship 30.
Yes.
Point number 37 below. The agreement for sale shall mention the detailed terms and conditions agreed between the parties for transfer of the estates and bearer plans and sale of specified assets of the said Kobang Tea estate by the vendor in favor of the purchaser in line with the terms recorded in this MOU. This is important, Lordship. Upon the execution for the agreement for sale, this MOU shall stand superseded. In the event of the purchaser deciding to assign its rights, liabilities, and interests accrued in terms of this MOU at any time subsequent to the execution thereof, the same shall be done only with the prior written permission to the vendor. Lordship, I ask myself this question: when there is this safeguard is already provided to them, where if there is any kind of a assignment or liabilities or interest is accrued, this will be done with the prior written permission to the vendor. Now, is there anything on record to show that we have sought for permission, they had denied, but instead that the apprehension, the Lordship was saying the apprehension, that we have sought for some kind of a thing which according to them is illegal. That's why that apprehension is there that an ex parte injunction order has to be passed. This is nothing on record as per this, because this is a preemptive thing. They are saying that their rights needs to be protected, no prejudice should be caused. Now question, is there anything on record to show that we are doing anything which is prejudicial to their rights? Any prejudice, that's nothing on record. Lordship, then be pleased to come to page number 86. Now, why I am showing 86, Lordship? 86 is the part of the agreement to sale. What has happened is that, as I have Lordship shown, as per 37, once the agreement for sale is done, the MOU is spent force. The MOU no longer is valid. between the parties. The agreement to sale comes. Now they might say tomorrow that is in regard with the MOU. Now any kind of safeguard is there in the agreement to sale or not. Now this is what I want to show in this agreement to sale, which starts from 71, and the relevant portion which Lordship, I would be pleased to look into is page 86, point number D. Lordship has got it.
Yes.
Assignment in the event of any party deciding to assign its rights, liabilities, and interests accrued in terms of this agreement at any time subsequent to the execution hereof, and the same shall be done only with prior written intimation to the other party. So the safeguard which was there in the MOU get reflected in the agreement to sale. So there is no question of any preemption, anything that has been projected to be projected by the plaintiff. Lordship, then be
In their injunction application,
Lordship,
what statement they have made showing apprehension that you
I
made?
have not found that I have written to them that I am going to assign it to someone.
No,
and then
without writing to
Yes.
the senior counsel submitted that there is they have come to know by some sources that you may. Is there any such statement in the?
I have not, because this is a caveat, this has come for the first time.
Yes, Mr. Datta.
Yes, my lord. No. Yes, my lord.
Yes, is there any statement?
That we have said that we are there, we are having an information that they are going to alienate their property and put in position of third party.
Where is that statement?
Just. Now she will find in page 169 in the plaint itself.
No, in your injunction
The
application.
same statement I have made, my lord. Now she will say that the injunction application is some just reproduction of the plaint, my lord. The same statement in the injunction application. Para 23, my lord. Para 24.
Oh, page number?
It starts from 169, my lord.
That's the plaintiff.
That's the
No, that is the plain only.
plain, my lord. In the injunction application also, there is some. I just.
Injunction application page number 213. One.
Para?
Para 22. Page 213. And then 214, paragraph 6.
No mere apprehension that.
No, I'm just add, if your lordship permit me, just add one thing, my lord. My learned brother colleague has produced before this honorable court 2 documents today. So we are not privy to the document earlier, my lord. Just I have gone through both the documents, which says that all post facto of the injunction application, my lord. Which says that they extended the validity of the power of attorney and the sale agreement without any consonance of the plaintiff, my lord. And thereby, they having now the power of attorney, though that power of attorney lapsed in 2024, my lord.
No, your plea was that.
Now,
your earlier plea was that it.
Now, so far our knowledge is concerned, my lord, because lordship will find that both the document not marked to us.
No, they have not yet appeared in the
Title suit.
Miss case as well as in title suit.
Well, fine, my
Only
lord.
if they appear and file their written objection, they
My
will
lord,
be
no,
able.
that's I'm nothing to
Para
say.
621.
My lord may, without going into all the merits, because my lord, now at this stage, it is difficult. So my humble submission is that it is the prerogative of the trial court to go into the merits, etc., because the trial court has not touched the merit.
No, I am only examining that. Do you have a case now that this court should grant some
But
protection?
now
Or
placing this,
should I dismiss it directly?
my lord, may kindly have a look that these two documents they have placed today before this court. That's not marked to us. It is everything behind back of us. That much more apprehension, that degree of the apprehension is much more now, my lord, on today. On today itself, my lord, the apprehension is much more than earlier. Because both, all those are happening behind back of us. It's not marked to us also. No consonance on our part while extending the validity of the agreement of sale and power of attorney. And power of attorney, my lordship is kindly appreciate. That it's
No,
only
it
for
is not marked to you because the steps were taken by the.
no, the copy of the government approval, etc. That was not so. Everything behind back of us. Now, on the basis of this power of attorney, my lord, they may do anything. Now, my apprehension
No,
is now on today.
let him complete yours.
Yes, please.
Let Mr. Das.
Yes, my.
Your name is Mr. S.J.
No, RJ Das.
R.J. Das. Mr. Das. Yes.
Lordship, then we used to come to page number 89. Now, Lordship, as I have already told that the MOU gets superseded by the agreement to sale. Point number L, Lordship, page 89.
Yes.
Lordship has got it.
Yes.
That in the case the parties herein fail to register the deed of conveyance for any reason whatsoever, as stated in clause 11A, the ownership shall always remain with the purchaser at all times, and the vendor shall have no claim over the property as mentioned in the schedule below.
No,
Now-
ownership.
Look,
Owner.
what this has been
This
agreed.
is this is against the law.
It's a clause that now this has been, what I want to submit, Lordship, is that first of all, there was a tea estate. The tea estate was sought to be sold to us. We as a company formed that company. We paid. Now, what is the consideration now, Lordship? I ask myself this question that what is the duty of the for us agreement to sale or whatever be the.
No, are you going to alienate the property?
No. How can I alienate? It is not even in my name. First, there will be a
Yes.
registered to for sale. There will be registered sale deed. Then it has to go to the revenue record. Then only I can alienate or do anything. I'm not understanding the apprehension and whatever, because Lordship made one more point I'd like to show. Lordship may be pleased to come to page number 47 for a moment. (47).
Yes.
Point number 1A.
Yes.
Lordship, I'm not reading anything. The figure is there, 44 crores, 97 lakhs, 87,157. This is the first agreement. There are two agreements to sale had been executed pursuant to the MOU. So this is 44 crores. This has been as per the first sale agreement.
Yes.
Then Lordship would come to page number 74.
Yes.
Point number 1, heading consideration for sale and purchase of specific assets. Amount is 4 crore, 3 lakhs, 12,843. If we both sum it up, it is 49 crores, 1 lakh. If we strictly look into the agreement to sale, all the amount has been paid by us. There is nothing left as per the agreement to sell. Now they are saying that there is a 3.5 crores part that is there. That's a matter of, that will be a matter of trial. Whether we are liable to pay, we are not liable to pay. Now the prejudice, the prejudice that is being strongly urged. What is the prejudice? I have paid everything. I am in possession of the tea estate. I am doing my work. Now I am not able to register the sale deed. It is to my peril because it is not in my name as of now. I am doing all the steps now. Government is not giving the, because it's a tea estate. It's not a normal land purchase thing between two individuals. Had it been a normal land purchase thing between two individuals, is a different thing. We are talking about 11,067 bighas. Now the purpose and intent of filing trying to somehow get an interim order probably is something else, which I am not privy to, because I fail to understand. I have given all the money as per the sale agreement. I have done all the, and I'm following up with the government. I want to get it registered. My registration would have failed if my power of attorney was not extended. The power of attorney is extended by the government. Now the point is that the government has issued this letter.
It is extended at whose behest?
It has to be at my behest. The power, whose behest? This is a process which behest would be like a power of attorney. Now, what has happened is that they had executed. I had given all the money to the seller. Now the seller says, whatever you have to do, I am giving you a power of attorney. You do whatever. Now, after getting everything, what is their thing is to the point that there is some called 3.5 lakhs, 3.5 crores, and some 19 lakhs.
Okay, we are not going into those disputes.
So that cannot be gone into whether a prima facie case. Now, summing up, Lordship, whether in the injunction petition, any circumstances, either directly or indirectly, so as to project that it is us who are doing some mischief. Any circumstances, any letter, any conduct. Now they are saying it's a conduct. Now what conduct are we talking about? Are we talking about a conduct of, it's a juristic person. We are a company. Anything that we would be doing, it is not that one individual be able to do it. Now, is there anything on record to show that warrants an ex parte injunction? Now question is that now at this moment, again I submit, Lordship, the question of ex parte injunction order will not appear. If any injunction order has to be given, Lordship, then I have to be given an opportunity to file an objection. Because I'm here, because it's not an ex parte injunction order as of now. At that stage, it was there, the notice was there, and
Yes.
then whether that order.
No, but why this court should assume that role when you can very well argue before the.
That's my submission. What I'm submitting, that's my submission, that this court now at this moment, now there is no question of ex parte. We will appear before there, we'll file our objection. All the papers will be before the trial court, and the trial court will look at all the papers of both the parties and pass any kind of an injunction order if it is warranted under law. That is my submission. Because at this stage, any kind of order is passed here may have an effect on my registration as well. Because there is an extension of it. Now tomorrow we will get an NOC immediately from the government. Government is not giving me the NOC. Now it's not that I'm not trying to get the NOC. So any kind of an injunction order in any worded manner will create a roadblock in getting my registration. Once not getting that registration, then again other things will follow. So, Lordship, what I pray is that this matter may be not remanded back. Letter may be relegated back to the trial court. The trial court will look at both the parties with our objection, within allowing us to file our objection, and come to a conclusion as to whether an injunction order is warranted in the instant case. That's my humble submission.
After 49 days, my lord. After 49 days. And Lordship, kindly one thing, I appreciate the submission of my learned brother, that the agreement stipulates that they will not assign their rights and liabilities what accrued upon them without written consent of the plaintiff. Do that, stick to that, my lord. They are violating that. So that agreement may be enforced upon. That undertaking, if Lordship at this stage, I have no objection, my lord. We'll go to lower court. Lordship may direct the matter may be taken up earlier and dispose the matter.
Mr. B. Datta, learned counsel for the learned senior counsel, assisted by Mr. S. Deka, learned counsel for the appellant, also Mr. R. J. Das, learned counsel for the caveator / respondent. This appeal under Order 43, Rule 1, within bracket R of the Code of Civil Procedure 1908 has been filed by the appellant, namely Messrs. APJ T Limited, impugning the order dated 1/12/2025 passed by the Court of Learned Civil Judge Senior Division Tinsukia in Ms. J case number 105/2025 arising out of title suit number 102/2025, whereby the prayer for grant of ad interim injunction made by the
Lordship, I'm extremely sorry. I just on the matter. I'll just be, Lordship.
okay, no.
No, Lordship, I'll be just coming. He is here.
Okay.
I'll be-
Okay, लिख ले. Made by the present petitioner was not considered by the trial court, and instead it issued notice to the opposite party fixing the date for next date for filing objection and for service report on 19th of January 2025. Learned senior counsel for the petitioner has submitted that the petitioner is a company within the meaning of the Companies Act 2013 and was earlier known as Assam Frontier Tea Private Limited and had entered into an agreement to sell an agreement for sale of Kwang Tea, agreement for sale of
Hubong Tea Estate.
Kwang Tea Estate to the opposite party, to the respondent, namely Kobang Tea Estate Private Limited. He further submits that the total consideration amount of the sale was agreed between the parties as to the extent approximately to the tune of 49 crores.
It was earlier agreed to 51 crores, 51 lakhs, my lord. Later on, it was reduced to, on some negotiation, to 49 crores, 1 lakh.
To 49 crores, 1 lakh. However, he submits that the respondent had yet not paid an amount of rupees, an amount approximately to the tune of rupees 3 crores.
3.5 crores.
3.5 crores out of the agreed amount. He further submits that the possession of the tea estate is presently with the respondent tea company, and they are continuing the business of the tea company over the property agreed to be sold. Stop. He further submits that though it was agreed which is the
My lord.
which is the that order which till when the
A 1 year validity period, my lord.
1 year validity period.
Yes,
which
page 41, my lord.
page one.
It's dated 5/10/2023. It's a government communication.
Learned counsel for the learned counsel for the petitioner has learned senior counsel for this petitioner has further submitted that since the land proposed to be sold belongs to tea garden and therefore no objection was required from the government of Assam in that regard. And to that extent and to that effect, the government of Assam in Revenue and Disaster Management Department by letter dated 5/10/2023 granted the no objection for registration of agreement to sale and power of attorney between the petitioner and the respondent in respect of the sale of the suit. Is there any suit property?
Yes, my lord.
Schedule.
Schedule A.
Says sale of the suit property within brackets Schedule A. He submits that the validity of the said no objection certificate was only for the period of 1 year, and within this period of 1 year, the vendor, that is the respondent, had
The purchaser.
the purchaser has to take steps for registration of the sale deed. However, same has not been done, as an amount of approximately 3 crores 5 lakh 50 lakhs is yet to be paid by the purchaser to the petitioners. He further submits that that after lapse of the no objection certificate granted by the government by its letter dated 5, what is the date?
5/10, 5/10.
5/10/2023. The occupation of the respondent over the Schedule A property has become unauthorized. He also submits that under such circumstances, there is every possibility that as the respondent is yet to pay an amount of rupees 3.5 crores to the petitioner to frustrate amount of rupees 3.5 crores to the petitioner, and for which the title suit number, what is the number of the title suit?
102, my lord,
Title suit number 102
2025.
/24
25, my lord.
25 has been filed by the present petitioner, comma, in order to frustrate any decree which the petitioner may get in the said suit. There is every possibility that the respondent company may transfer the possession and occupation of the Schedule A property to a third party. And under such circumstances, the petitioner would be highly prejudiced. Stop. Learned counsel for the petitioner submits that under aforesaid circumstances, the petitioner had filed a title suit number 102/2025 seeking relief in the form of a direction to the what relief you sought for in
In page 172, my lord. That can be reproduced, my lord.
seeking reliefs, seeking amongst various relief, the relief of a direction to the defendant company to pay the balance sale consideration amount of rupees 3,50,000 crores.
3 crores 50 lakhs.
Sorry, 3.50 crores.
Right.
And also a direction to execute the sale deed and get it registered within a period of 3 months of filing of the suit by the present petitioner. Learned counsel for the petitioner has further submitted that in the said title suit, the petitioner had also filed an application under Order 39 Rule 1 and 2 read with section 151 of the Code of Civil Procedure, which was registered as
105.
Miss Case number 105/2025. In the said suit, in the said Miss Case, the petitioner had also prayed for grant of an ad interim, ex parte ad interim injunction against the present respondent by restraining them from transferring, alienating and parting with the possession of the Schedule A land during the pendency of the connected title suit. Learned Senior Counsel for the petitioner submits that in spite of a good case being made out by the petitioner for grant of ex parte ad interim temporary injunction, the trial court by the impugned order dated 1/2/12/2025 has only issued notice to the opposite parties fixing a long date long date with a gap of 49 days in between on 19/1/2025 for service report and written objection. He submits that if the injunction, temporary injunction prayed for by the present petitioner is not granted, it would there is every likelihood that the petitioner may alienate the respondent may alienate the Schedule A property and frustrate the title suit filed by the present petitioner. On the other hand, learned Mr. R.J. Das, learned counsel for the petitioner, learned counsel for the respondent, has submitted that there is no infirmity or illegality in the order impugned by the petitioner in this appeal, as the petitioner had failed to make any averment showing any urgency for grant of ex parte ad interim injunction, and therefore the trial court was right in issuing notice to the opposite parties, within bracket present respondent. He further submits that in the meanwhile, the government, by its order dated 10/12/20,
9/12.
9/12/2025 has extended the validity of agreement for sale and power of attorney or till when it was until
further approval of the government.
until further approval of the government regarding registration of the conveyance deed in respect of the Obang Tea State Private Limited. He therefore submits that the apprehension shown by the learned senior counsel for the petitioner does not have any basis. He further submits that in the memorandum of understanding, which was earlier entered into between the parties, and thereafter in the two agreement to sale entered into between the parties, there are specific stipulations to the effect that any assignment, any party deciding to assign its right, liability, and interest accrued in terms of the agreement at any time subsequent execution thereof shall be done only with the prior written intimation of the other party. He therefore submits that there is nothing on records to indicate that any such step has been taken by respondent to assign its right to a third party, and therefore the apprehension shown by the petitioner in its application under Order 39, Rule 1 and 2, that the respondent may alienate the Schedule A property to any third party does not have any basis. He submits that now, as the petitioners are, as the respondents are aware about the filing of the title suit before the trial court, as well as filing of the injunction application before the trial court, they are ready and willing to appear before the trial court and to contest the injunction application filed by the contest the suit as well as injunction application filed by the petitioner before the trial court by filing written objection. And therefore it would be appropriate. Therefore he submits that it would be appropriate for this court to direct the trial court to decide the matter after giving opportunity to both the sides and after taking into consideration of the pleas of both the sides. Stop. I have considered the submissions made by learned counsel for both sides. On perusal of the impugn order dated dated 1/12/2025, 25 passed in Misj case number 105/2025, it appears that the trial court had not made any observation regarding merits of the case of the petitioner or otherwise. It has only issued notice to the respondent side, notice to the present respondent fixing 19/1/2025 for filing written objection by the opposite parties. The question to be considered in this appeal by this court is whether trial court was correct in not considering the prayer for grant of ad interim injunction to the petitioner on at the first instance itself, and whether it was right in issuing notice to the petitioner, respondent. If we peruse the provision of Order 39, Rule 3 of the Code of Civil Procedure, it appears that that in all cases where a prayer for grant of temporary injunction has been made, the normal rule is for the court, normal rule for the court is to issue notice of the application to the opposite party. However, notice can be waived only if the court comes to a conclusion that the object of granting the temporary injunction would be defeated by the delay caused in issuance of the notice. Now, whether in this case the trial court was correct or not in issuing notice has to be considered on the basis of the averment made in the injunction application. Stop. Since this court is intending to dispose of this appeal, on the day of motion itself, it is not inclined to go into merits of the case of both the parties as regards grant of injunction, temporary injunction in depth, as it may influence the trial court. However, it proposes to examine whether the petitioner has made out a case for grant of ad interim temporary injunction in his injunction application. If we peruse the
Ex parte injunction, my lord.
ad interim ex parte injunction.
Yes, my lord. Right.
If you peruse paragraph number 22 of the injunction application filed by the petitioner, it appears that the apprehension of the petitioner that the respondent company may transfer the possession and occupation over the Schedule A property to a third party is mainly based on the fact that the no objection certificate no objection certificate granted by the government regarding registration of the regarding period of validity of the agreement to sale and power of attorney has lapsed. No other basis for no other basis for no other material on the basis of which said apprehension is shown by the petitioner is there in the can be discerned from the perusal of the injunction application. Further, on perusal of the letter dated 9th December 2023, 25, issued by the Deputy Commissioner Tinsukia, and produced by the learned counsel for the respondent today before this court, it appears that the validity period of the agreement for sale and power of attorney has been extended by the government until further approval of the government regarding the registration of conveyance deed in respect of Kobang Tea Estate Private Limited. Hence, the only apprehension shown by the present petitioner in the injunction petition for praying for grant of an ex parte temporary ex parte ad interim temporary injunction does not appear to have any basis. This court, without commenting on the merit and or otherwise of the case of the petitioner or the respondent in the pending title suit or in the injunction application, is of the opinion that there is no averment in the there is no sufficient materials on record on the basis of which trial court would have reached a conclusion that the object of granting of injunction would be defeated by delay if notice is issued to the
If
opposite
notice is
party.
not dispensed with, my lord.
If notice is not dispensed with to the opposite parties.
My lord.
Hence, this court does not find any infirmity or illegality in the impugn order. justifying any interference by this court in the impugn order in this appeal. The respondent, you will appear before the.
Yes.
you-
No
you
notice is
will-
required now, my lord.
No notice. As the respondent is represented by its engaged counsel before this court, the respondent is directed to appear before the trial court in Ms. J case number 105/2025 in connection with title suit number 102/2025 on the next date fixed. That is on 17. That is
So
on
19
19.
is too much, my lord. Made fixed on 5th of January, my lord. Keep on because both of us here.
No, you make prayer before the
The-
trial court.
And we have to file our objection also. That will-
19
Let it, let
before
then,
nine-
well, my lord,
19th
may I request one thing, my lord? On 19th itself, the matter may be hard. Because if they file objections, then thereafter the hearing,
19 January 2025. The trial court is directed to dispose of the application under section 39, under order 39, rule 1 and 2 of the CPC as expeditiously as possible on its part.
on the
With
date
our
fixed, my
profile.
lord. On the
With
date
our
fixed.
profile. No.
Okay. Then
With
it
our
may
profile.
continue for 6 months, my lord. This is the experience in the trial court.
With above observation, this first
Dispose
appeal
of it.
is disposed of.
My lord. That's the finest thing. Without dismissal, disposed of. Grateful, my
I disposed of
in terms of the price. Oblige.
I just fixed that to item 45. May I please, the lordship? My lord, the issue involved in this petition is that, my lord, the petitioner filed an application under Section 8 of the Land Grabbing Prohibition Act, my lord. And that petition has been dismissed mainly on the ground that, my lord, citing that, my lord, the land against which application has been made, that is very small quantity of land. It was 4 kotha and 10 lesas, my lord. So, my lord, the application under Land Grabbing Prohibition Act is not applicable, my lord. That is the main issue, my lord.
Is there any legal bar?
No, my lord, that is not, because in that order, my lord, an order passed by this honorable has been wrongly cited and interpreted, my lord. That I will put it.
Where is the impugn order?
Impugn order starts at, my lord, page 60. All 5 petitioners are present with their learned counsel. Learned counsel for the petitioner as well as respondent number 1 and 2 also present, heard them as well as parties. We have already specified in order dated 24/9/2025 that report from the circle officer was called on 30/8/2024 before taking cognizance. The report was submitted. Thereafter, another report, the report of the circle officer was not conclusive, my lord. But the report of was called for from OC of Muradar PS fight order dated so. Thereafter, the case was posted for hearing on 25/11/6/12/1912. But ultimately, someone was sent on 18/1/2025 without any order on cognizance. Thereafter, respondent number 1 and 2 have appeared and submitted WS. It is clear that there were some irregularities in the matter of taking cognizance, which can be rectified, streamlined now after hearing the learned advocate of both the sides. Cognizance is an important matter, and Section 8(3) proviso of the Assam Land Grabbing Act specifically says that special tribunal shall not take cognizance of any such case without hearing the petitioner or the aggrieved person, as the case may be. Honorable Guwahati High Court in Ray, State of Assam, cited as so in reported in stated that
all the section 8(3) of the Act 2010 is that for the purpose of taking cognizance, the special tribunal may consider the location of the land alleged to have been grabbed or the estimated value of the land or the nature of land grabbing or such other relevant matter. In view of the above laws, this court is inclined to hear the learned advocates of both the parties on the next date. This court shall also hear the petitioner aggrieved person on the next date personally. After personal hearing of the petitioner, as well as the learned advocate for the petitioner, we find that this petition has been filed only for 4 Katha and 10 lesser land in Kopahbari Mauja, which is a village land. The quantum of land is also very less. Therefore, it appears that this dispute is not connected to organized attempts of land grabbing, which is dealt by Assam Land Grabbing Act 2010. The preamble of the Act of 2010 makes it clear that this act is applicable only for organized attempt on the part of lawlessness person in order to grab land. Honorable Guwahati High Court in Re State of Assam cited as so-and-so has specifically laid down law that the value of the land as well as the location of the land is also significant. Such being the position of law and fact, we are of the opinion that this is not a fit case to take cognizance under Land Grabbing Act. The petitioners are at liberty to move before so-and-so. Now, my lord, that the judgment that the learned court, trial court has referred to, that I would like to produce before your lordship, my lord. This particular judge has been totally
Yes, Mr. Hussain,
misinterpreted, my lord.
you are appearing.
Lordship, I am appearing for the caveat of response number 2, 3, and 4.
That judgment has been referred, my lord. The relevant portion is paragraph 21, my lord. In total misinterpretation of this judgment, my lord, this application has been dismissed. Your lordship may peruse relevant paragraph 21, my lord. Because in fact, the act also doesn't say regarding the quantum of land, my lord. And 4 Katha 10 lesser is not a small land, my lord. It is around 1 bigha, my lord. Paragraph 21, your lordship has got it.
Yes.
So paragraph 21, because this judgment has dealt with this issue in paragraph 21, my lord. Insofar as the question number.
What was the question number 2? Whether the provision of section what is 8(3), section 8(3)?
8(3), my
Read 8(3).
Yes, my lord. Section 8, my lord. Every special tribunal shall have power to try all cases arising
No,
out
read
of.
8, clause 3.
Yes, my lord. The special tribunal, for the purpose of taking cognizance of the case, consider the location or extent or value of the land alleged to have been grabbed or of the substantial nature of the evil involved in the interest of justice required and any other relevant matter involved in the case, provided that the special tribunal shall not take cognizance of any such case without hearing the petitioner or the aggrieved person as the case.
Now read 21. Not section, the judgment, para 21.
Yes, my lord. Insofar as the question number 3 is concerned, all that section 8(3) of the 2010 Act says is that for the purpose of taking cognizance, the special tribunal may consider the location of the land alleged to have been grabbed or the estimated value of the land or the nature of land grabbing or such other relevant matter. This is very much in order and there is nothing unusual about it. Regarding the proviso, it says that the special tribunal shall not take cognizance of a complaint without hearing the petitioner or the aggrieved person. That is only says in the proviso. As per subsection 2 of section 8 of the 2010 Act, the special tribunal may take cognizance either suo motu or an application by the aggrieved person. If the complaint is by way of application, then the special tribunal shall hear the petitioner, and in case of suo motu proceeding, the special tribunal shall hear the aggrieved party. The hearing envisaged in the proviso has to be preliminary hearing and not a substantial hearing. Only for the purpose of special tribunal prima facie satisfying itself that it is a fit case for taking cognizance. Thus, section 88(3) of the 2010 Act read as a whole provides for a prima facie satisfaction of the special tribunal before taking cognizance only to
Okay,
ensure that.
we are issuing notice. We are issuing notice.
But Lordship, they could have approached the learned special court under the appellate provision, Lordship. Section 13 of the Act, Lordship. There is a provision for appeal.
Appellate tribunal is there.
No, my lord, it has not been constituted yet, and therefore, my lord, CRP is maintainable now, my lord. Some other matters are also pending, my lord, because appellate tribunal has not been constituted yet, my lord.
Whether it has been constituted or.
If suppose the special tribunal is not constituted, Lordship, special court, Lordship, the issue involved is purely of civil nature, Lordship. And that has also been observed by the learned court below, at page 62. So, we may kindly see page 62.
No. The trial court, dismissed the case of the petitioner mainly on the ground that the area of land was very less.
This is what the provision, section 8(3) and the paragraph 21 of the judgment says, Lordship.
It
There
does
has
not-
to be prima facie satisfaction regarding the area, value of the land, and
No, it does not lays down that this much area.
value is involved, Lordship. Value of the land is 8(3), Lordship. May I kindly see.
This question is required to be examined. We are issuing notice.
Only
And my lord, my one humble prayer is then, my lord, because if your lordship peruses the officer of the report of the circle office and police report, which is which says that, my lord, the land, it has been grabbed by the respondent party. So may I pray that in the interim, my lord, the status quo of the land may be,
Whose possession?
we are possessing, Lordship.
they are possessing and they are undertaking construction there, my lord. We have annexed the photograph also. So status quo as regards the, because otherwise, my lord, it will be irreparable loss on the part of the petitioner.
No. Though land grabbing case has been dismissed, there is no bar for you
Yes, my lord.
to go to civil court. So if you want any other relief,
Because both the
till
parties
this
having
issue is
documents.
decided.
And or otherwise, my lord, since they have appeared, my lord, your lordship may fix a short date for admission hearing and then your lordship may decide the
You will
matter.
be filing any objection?
Lordship, I file.
Heard. Mr. Your name is not there in the. In the. Heard Mr. BP Bora. Learned counsel for the. Petitioner. Also heard Mr. M.I. Hussain, learned counsel for the caveator. This application under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 30/10/2025 passed by the Court of London, Additional Session District Judge Ojai in special within bracket land grabbing case number 5/2024. Learned counsel for the petitioner has submitted that the trial court had heard by holding, in the impugn order, that as the quantum of land is very less. Hence, it is not connected to organized attempt of land grabbing, which is dealt with by Assam Land Grabbing Act 2010. He submits that the trial court erred in correctly interpreting, erred in not correctly interpreting the ruling of the division bench of this court in re-state of Assam, reported in 2018 2 GLR 313, while dismissing the case filed by the land grabbing case filed by the petitioner. Stop. The issue raised by the petitioner in this revision petition needs to be examined by this court, hence issue notice. Since Mr. M.I. Hussain has already appeared for all the respondents, no formal notice need to be issued to the respondent. Learned Counsel for the caveator/respondent submits that the respondent may be allowed some time to file a written objection against the petition filed by the present petitioner. The prayer is allowed. January tata date dio. Let this matter be listed on 22nd. Records would be necessary. Let the records of land grabbing case number,
Then number 5 of
land
2000.
grabbing case number 5/2024 be called for from the Court of Learned, Additional District Judge Hojai, District and Session Judge Hojai, the registry to take steps for recognition in the records. Let this matter be listed when 22nd January.
My lord, an endeavor may be made to dispose of the case, my lord. Because my lord, it is a small issue. So endeavor may be made to dispose of the case.
Endeavor will be made on that day, not
Yes, sir.
today.
Not today, my lord, on that day.
So-
That is the observation.
So what will happen on that day?
Maintainability may be kept open, Lord. Maintainability of the petition.
Everything is kept open.
Okay.
Oblige, my lord.
Item 38, some urgency there. My lord, may I pray for listing on Monday, my lord?
Monday ke बाद this week. Monday it may not be possible. Next week is a motion week. And we have
That's true.
list.
But some urgency is there, my lord. The rice, the paddy field is, my lord, repaid. We have to harvest the, my lord, paddy, but the other party has restraining us.
Betul. Chart kon diyorsun. Those who don't have urgency, please don't mention. And those matters will be shown as December. Kita. Wednesday. Item number
Item number 38, my lord.
38 could not be taken up due to paucity of time. Release this matter on 17/12.
Meet please, your lordships. My lords, I'd like to mention item number 33 of today's list. This pertains to withdrawal of money in MSA appeal, the portion that has been awarded. My lords, there is an extreme urgency in the matter. The younger son of the petitioner, he is studying MSc. His second semester admissions are due. So can it be taken up next week, my lords?
Wednesday.
My lord, item number 34, my lord, had allowed the upgradation, my lord. My lord, can it be taken on Monday, my lord? At 2 p.m., my lord had fixed that matter at item number 34, my lord. The similar,
Why you were not at two?
my lord, I was there in the, my lord was hearing in the
Why
matter.
it was not?
My lord was hearing in
Okay.
one matter was, my lord. was
Okay, on Monday.
Deeply obliged. my lord.
Nine. No, Tuesday, there are, it may be on either Friday or Wednesday. Wednesday. What is the urgency? No urgency. It will be shown as leftover. Other matters where there is no urgency will be shown as leftover.
Yeah, please, your lord. I'm back to me, sir, item number 39, my lord. This is there, this relates to IA, my lord, for early hearing of RFA number 5 of 24, my lord.
I for early hearing,
Early hearing.
Wednesday.
But it,
May please, your lordship. Let's say item number 27, 28, and 29. Then date may be fixed, lordship.
Date will be fixed by registry.
item number 15, maybe then 26.
Beg the lordship, my lord. If the lordship is not displeased, my lord. Item number 25, it may be listed on my lord in January 21 or 22, subject to your lordship's
No,
convenience. my lord.
registry will fix the date. You
This is
pray
a very
before-
urgency matter.
pray
because,
before
yes.
registry.
The lordship is not. Item number 23, the order is due to paucity of that order is.
Pray before registry.
They tell me that this observation is required that it could not be because your court case is there, I can act. This case could not be.
When you want.
After 4 weeks, it's all right. After vacation, but
Item
this
number-
order, why? Because
Would not be taken up due to
due to
paucity
paucity
of
of
time.
that's it enough.
Let this matter be listed
Then.
on a date to be fixed by registry.
Our